Welcome to the show. You look incredible, like a dessert that owns a yacht.
That's exactly the vibe I was going for. You know, sweet but slightly out of your tax bracket.
Mission accomplished. How does one even shop for a suit when you're
Gold on my neck, gold on my hand, purple with the stripes, that's the walk of a man. Sidewalk shining, city lights humming, every step I take, they know a boss is coming.
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age.
Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThATuMBRELLAgUY. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me.
You know what? I talked to your mayor.
Rolling up, I'm feeling fly, yeah, I'm so damn fresh. Got that platinum grill, blinging in the chest. Diamonds in my mouth, shining when I speak. That umbrella guy, flossing, speaking geek. Ice on my teeth, I'm dripping so hard. Platinum grills, I'm the king of the boulevard. Throwing money in the club, I'm the baddest in the game. No one gets a pass, ooh yeah. Crushing all these lines, yeah, I feel fly. Rolling on the dubs, that umbrella guy. Iced out clothes on the boulevard. You ain't a comic gangster, don't be playing hard. Ice on my teeth, I'm flying so high. Dropping the bass, that umbrella guy. One grill to rule them all, one grill to bind them. Baby, I'm so iced out, gonna blind them. Rolling in town, I'm an army of one. Doing verbal walk-bys, blazing like the sun. Riding in my whip, crushing false accusers. Dropping off the bass on the real abusers, yeah. Living life fast, no time for the slow. Justice on my mind, stacking up on that flow. Life in the fast lane, no time to blink. Ice on my teeth, watch it when I speak. Chillin' on my rhymes, never missing a beat. Ice on my teeth, yeah, I'm living that sweet. That umbrella guy, bringing the platinum heat. Crushing every hater, no time for defeat, ooh yeah.
Oh, yeah, indeed. What's up, my friends? How's it going tonight? Man, we actually had something so successful yesterday. I'm going to have to give it some shout-outs, talk about that. Then we're going to hit one heck of a document tonight. Oh, my goodness. It is so interesting that I had a topic I was going to cover today. It spent all of my day wasted away going through transcripts, looking at it. But then one banger of a freaking document dropped right in the lab today. So I guess we'll hit that one tomorrow. But I want to talk about something that was amazing last night. I want to talk about a little bit of the feedback for not a memorial fund commemorating the bench. Look, I want to show you a little bit of the feedback we had there. You know, we had things like, I loved it. Amazing. I guess Megan and Tug, I don't watch those channels, but they're talking about the memorial bench. I'm like, oh my God, this is none of your business, man. Nobody's business. Yes, there were also such wonders as fantastic and Megan and Tug, your leader, the boss, he stole that memorial. It's not on this property. We have the videos to prove it. Yes, it seems to have gone over very well last night. Oh man. Apparently a few people got really, really butthurt about this whole thing that happened yesterday. If you missed yesterday, for some reason, by the way, we decided that it would be a beautiful thing to put together a memorial bench. Again, the main topic today is not this, but I have to tell you about this because this is really funny. We decided we would put together a memorial bench commemorating the memorial bench that never happened, right? Because that makes sense, yes. Again, if you'd like to participate in that, that is still always commendable. You may do that at your leisure, but we did have a little feedback on that. Like I said, it was interesting. It was very interesting to check out. Let's look at a little bit of it together. Let's actually go to the transcript for instant replay. You know, oh my God, let me pull up my timestamps. Give me a second. I went through that, man, last night. They broke the protective order again last night. That was going to be my topic to lead off. I'll do it tomorrow because it's a crazy one. Yeah, they decided to stock the wrong vehicle, but anyway, we'll do that one tomorrow. They stocked the wrong vehicle. Oh my God. Yeah, but I mean, it really, when you're gonna mess up, when you there's the right way, the wrong way, and there's the really bad ecosystem way. I swear. Here's some of that feedback though. Here, for example, you can see, oh my God. Now, you got to remember when we're talking about the memorial, first of all, you have to remember that it fundraised in November 26th of last year. So it has been over a year, but it, like the barn, apparently are still coming. And again, we will discuss all this tomorrow more in depth, but I thought we'd get a little review there. But we got anyway, I got a message before tonight that I guess Megan and Tug, I don't know what channel it's on or whatever, even though we get in-depth discussion. So obviously they do know what we're doing. They're talking about the memorial bench. Like, oh my God, that's none of your business. That's nobody's business, man. Yeah, it's nobody's business, man. You know, see, that's a great excuse when you fundraised $4,000 and then you tell people that's a private affair. It's not a private affair when you ask the public for thousands of dollars, you know? I mean, they're like, no, we don't have to prove anything. The family's going to do it when the family wants to do it. And that's it, period. You know, just like the permits. The permits will happen when the permits happen, right? The family's going to do it when the family wants to do it, period. And how dare any of you monsters out there in that chat, how dare you expect any answer for where that's at? The holidays are here. Nobody knows what's going on. We do, but they don't have to know. You know, once it's up and done, yeah, everybody can see it. But you know, not now. So apparently they're going to be putting up a bench on Hale's part of his property that is going to say something like the bench that never was. The bench that never was. I told you it would be amazing. I told you. The bench that never was. I'm telling you. Or something like that. Idiots. These people are literally literally psychotic. Oh. Oh my God, I love it. Grifting, you know, the grift, the lie, the speculate, you know, and people have used them to them for so long. I mean, there's so many people listening and they just believe their bullshit. It's crazy. Yeah, you know, if the memorial bench that they raised $4,000 for had ever materialized, we would never be able to put up a memorial bench for the memorial bench that never materialized. It has been, like I said, 13 months, and they keep telling their donors it's coming. And it will be funny if it materializes now because we forced the hand. I think that would be even fun. They'll be like, "Oh, look." They'll be like, "No, we publicly shamed you, and you're afraid we're going to deliver a bench before you deliver the one." Now, there's a couple of other places this is discussed too. Give me a second. And then, like I said, we will hit our wonderful documentation there. But, yeah, you know, you got to respect the family, man. You got to respect the family. They keep saying that. I don't actually think that it's respecting the family when they went with the, if your leader didn't steal the memorial, there wouldn't need to be there wouldn't be a need for revenge in the first place. Revenge? That's an interesting. Yeah. Hey, Megan and Tug, your leader, your boss, he stole the memorial. Remember, we were talking about, by the way, their quote unquote memorial before was 2 2x4s with a little plastic piece in it. And one of those 2x4s was part of a no trespassing sign. Apparently, a no trespassing sign is part of a memorial. That's an amazing epiphany. But yeah, I mean, they're still going with they have video too. That's what they said. They have video and they would show it to us. It's going to prove that Jeremy was there, George was there, some other people were there stealing a memorial, but they're not going to show it to us. You know, they show everything else to us, but they're not going to show us that one. And weirdly enough, they didn't show it to the cops either. So weird, isn't it? You know, very weird. They were like, yeah, it exists though. You just got to believe. But now look, now the family doesn't want to get involved with the drama. It doesn't want to be part of content. So $4,000, you know, like get those wheels chugging and blame somebody for stealing a memorial that wasn't a fucking memorial to begin with. It was a bunch of, you know, I'm going to say this, and this may sound like an asshole thing to say, but I'm going to say it anyway. If I dump a garbage bag by the freaking road out here, that's not a memorial, even if I say it is. That's trash. And sticking a 2x4 out here, and one of them being a no trespassing sign, that is not a memorial. That doesn't commemorate anything. It commemorates pettiness. That's what that did. It didn't celebrate life. It celebrated pettiness. So don't try to sell that. And it became a $4,000 thanks for nothing, but it's private. It's all private. Remember, everything's private. Don't have to show your receipts. It's the greatest grift on earth, right? No receipts, no nothing, guys. No nothing. Amazing. You got to admit, that is a pretty good one. That is. Now, there's one other timestamp that talks about this, too. Let's roll that up here. Let's see, where are you? Now there may be a few more later on, but I haven't motivated to go all the way back and mark them. I just wanted a few for today before we talk about this, you know, because apparently, you know, the game is well, you know, they got nothing to talk. They're talking about their talking. So, you know, they're talking about the memorial. That mofo, he stole it. He stole it. And he's got, look, they try to tell you again They have video. There's video. There's going to be video. God, they cried a lot about people too. Look, Rosalind Duke, Georgie, Tiggy the Bounce, Tizzy. They really spent a lot of time. They doxed where Miyagi was yet again. Crazy stuff. Again, if you tune into no other show for the next week, well, actually, next week you need to tune into a lot of shows. But I'm telling you, next Tuesday is going to be absolute fire. They talk about $7,000 for lawyers and all this stuff. I'm curious if they'll ever fundraise another thing after the bombshell I dropped for you. I am very serious. Oh, like I said, hype it everywhere, because they need to be watching too, because it's going to be real fun. All of you will be like, oh, look, gasp. Yes, that is a different language. Look, gasp. That's really tough. Now today we got a wonderful document, and it is not a short document, by the way, but it is a banger of a document. It is an answer to Daniel Owen. Now, Big Dan Owen here, remember the last piece of this puzzle right here was talking about motions to dismiss, and it had such wonderful bangers like, I don't have to care. I liked that one. Wasn't that fun? I have qualified immunity. You can't make me. Nah, 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 nah. Many of those wonderful arguments. So we got a banger of an argument that kind of answers that. Yeah, no, Dark Mage. I think I spoke French too. Lasai. This is LRECKS. Wow, isn't that amazing? Whew. That really is about all I got there. Today is Tuesday. Yep, you're right. It's Tuesday. Well, let me tell you that. No. Oh, it all lines up with everything that's going on next week too. Remember, we have a banger of a week next week. Remember, there's bombshells are dropping. We got some court cases that ain't stopping. It's gonna be all kinds of fun. You're gonna enjoy it. So this is again early on in the case. Now, like I said with this too, I'm gonna be very clear. These are the hardest fights to fight. Why? Because when the people that are there that are supposed to represent you, when they actually betray you, we somehow have been forced to give them qualified immunity. They actually get excuses like, well, even you remember ignorance of the law for you and I. That is not an excuse, but for them it is. It's also, well, I didn't want to, so I didn't have to. That's an excuse. But there are things that don't work as excuses. So remember again how everything came together, and let's check this out. So this is the plaintiff's response in opposition to defendant's motion to dismiss with prejudice. Again, remember, with prejudice, they're saying they shouldn't be able to file this again. Again, Dan Owens is his answer last time too. My favorite part of it all was you should have sued Levy County. Remember that. That was the best part of it all. But this is document 9 too, for those keeping touch. All right. So Jeremy Hales and George, that would be the plaintiffs there, by and through undersigned counsel, respectfully submit this document, which we already read the title to. Defendant's motion suffers from a fatal procedural defect that warrants denial. It repeatedly references and relies upon exhibits to support factual assertions that contradict the allegations in these complaints, yet the exhibits are not attached to the motion. Whoopsie. Now, of course, what's happening right now. I can predict this. Like they're hitting up they're hitting up counsel and they're like, oh my God, we forgot to add those in. Will you allow those to enter? Now, the problem will be with that again, and it'll be interesting. They filed again without putting them in. And the whole argument here is like, well, you didn't put those in. And, you have Jeremy Hales having to spend quite a bit of money. That's what happens, when you set up and you put together dozens of pages to argue, it costs quite a bit of money. So I can tell you the way it'll go is they'll argue and they'll say, well, we forgot to put those in. Oh my God, can we file it again? And that'll probably be a little fight. It'll be interesting to see because there's nothing there. So the court cannot consider these phantom exhibits when ruling on a motion to dismiss under well-established 11th Circuit precedent. That is right there. Hey, you can't say that check out these exhibits and then not attach some exhibits. Whoopsie. Even setting aside this defect, plaintiffs have adequately stated claims under 42 U.S.C. 1983 that should survive defendant's motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true and viewed in the light most favorable to plaintiffs, remember, this is how things are supposed to be viewed. If you are thinking about going forward with a case, you have to look at it in the light most favorable to the plaintiffs. Establish plausible claims for relief based on defendant's failure to give full faith and credit to valid protective orders as required by 18 U.S.C. 2265 and for violation of plaintiff's due process rights. Furthermore, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for the conduct alleged in the complaint. For these reasons, as more fully set forth below, yep, that should be kicked to the curb. That should be kicked to the freaking curb. So the factual background. So this case, this actually is a good breakdown if you don't understand how this arises. And it's very disturbing when if you did not read Dan Owen's argument for why this should be dismissed, you really should, because it's very disturbing. It's disturbing in the right that you say you get a protective order. Dan Owen argues that investigating you, that's normal. And that's okay. Not enforcing, well, that's he's not really required to. The courts are required to give full faith and credit. The cops are, but not Dan Owen. Dan Owen's not his prosecutor. He's not. And so on. Really wonderful things that, again, I'm sure as a taxpayer and a voter, I'm sure that you really wouldn't agree with. In fact, like I said, if the ecosystem was looking at this outside of Jeremy Hales, remember, again, they are anti-Jeremy Hales. So they're pro anything that goes against Jeremy Hales. If they weren't, however, they would see this as a very alarming statement because Dan Owen is saying, again, if you had a protective order, if there was something wrong there, it wouldn't matter. Now, again, he would probably only ever make this argument for Jeremy Hales and for George. But there is something terribly wrong in Levy County for this argument to exist ever. So the case arises from defendant Dan Owen's alleged failure to give full faith and credit to protective orders issued by an Ohio court in favor of plaintiffs Jeremy Hales and George. Plaintiffs filed their complaint September 21st, 2025, alleging that the defendant, a state official employed by the state of Florida, violated their civil rights under 42 U.S.C. 1983 by refusing to recognize the validity of their Ohio protective orders and instead initiating an investigation into whether the protected person, that would be plaintiff Hales, had committed the crime of perjury when obtaining the Ohio protection orders. Yes, instead, really think that out. Instead of protecting the person, they decided to investigate the person. And I very much think there is another letter that they are hiding. I really do. I think they are sitting on something else that they have not turned over. I don't think when I look at the police and how they responded to this thing, saying that, they were cautioned about going forward, I think there's another letter. I really do. I think they're gaming. And they do that a lot. They do it with body cam footage and all kinds of other madness when you look into stuff like this. So the complaint alleges that plaintiffs are protected persons under 2 valid orders of protection issued by the state of Ohio on or about October 30th, 2023, after a hearing in which the restrained parties, LMNOP and John Crook, had a reasonable notice and opportunity to be heard. The complaint further alleges that when plaintiffs presented these protective orders to Levy County Sheriff's Office requesting enforcement, defendant Owen refused to recognize their validity and instead investigated whether plaintiff Hales, a protected person, had committed the crime of perjury in obtaining them. As alleged in the complaint, defendant's email to Levy County Sheriff's Office dated October 30th, 2023 stated, quote, "Oh, can you mail me the petition?" I don't even know what kind of voice to do with him. That Hales filed in order to obtain this order of protection. If you don't have a copy, please request one from the clerk of Smartt County. I want to see if Hales committed the perjury in the petition. Now, the email was attached to the complaint as Exhibit 3. Now, again, I think there is another email too. I very much do. But we have yet to have one turned over. Now, November 20, I also believe that because they were very cagey in the fact that they didn't turn over things. Look at that bench money still rolling in. Look at that. You guys, man, we got the bench bucks going in. Bench bucks. Do bench bucks. Now, I do want to make this clear too, while we're talking about that. There will be a bench. It will be real. It is not a joke. That is not like a put off or anything else. There is going to be a bench. That is not a joke. Okay. There is permission. It will be put on Hale's property. That is a 100% happening thing. So just to make sure people understand that it is for full faith, full blessing, that it's all good to go, Now, again, as I learned from the anti-Hales, anything left over, that goes in my pocket, baby. But that has also been, we're not giving money to, a group of people like the bench. There is no bench to give money to when we're commemorating the bench. So, and for hell, again, everybody thought this was a fun idea. So I was like, that'll work. So it should be pretty fun to see. So anyway, let's continue. I just wanted to make that clear. People, if you see that, you think it's a joke. No, there will be a bench. Oh, it's going to be glorious. But on November the 21st, 2025, the defendant filed a motion to dismiss with prejudice, arguing that, number one, he is absolutely immune from the suit. Number two, plaintiff failed to state a claim upon which relief could be granted. And number three, he is entitled to qualified immunity. Those are the arguments, again, Dan Owens comes in for throwing down on Hales and not enforcing the protective order. So throughout his motion to dismiss, he repeatedly references 3 purported exhibits that we 1 through 3 to support factual assertions that purportedly contradict the allegations in the complaint. Specifically, on page 2 of his motion, defendant states, quote, Mr. Hales and George each reported violation of the protective order to Levy County Sheriff's Office, and the 8th Judicial Circuit State Attorney filed charges in Levy County cases versus Preston, Levy County number, blah, blah, number, blah, blah, and blah, blah. Now, these are phantom exhibits. They don't exist, don't exist at all. Despite these references, they fail to attach these purported exhibits to the motion to dismiss, which is something that was noticed before, by the way. Let me just note that. It was noticed, but there are certain things that come up in these filings that you don't tell opposition that I'm not shilling for the fucking state. Okay. So when I see an error in there, they already suck up way too much of our money for bullshit like this. The state is protecting Dan Owen. They will spend a lot of money protecting Dan Owen. And then if they decide that he is stripped of any immunity, then they will attempt to settle with Jeremy Hales. If he decides to settle, awesome. You know, and it's understandable too. If he doesn't, because it makes a point. And if he doesn't, that's awesome too. You know, for whatever there. That's funny. The bench, the judge is going to throw at the ecosystem legally. That's hilarious. Here's a question. Isn't asks, did Bruce or Lisa interfere by writing to Owens accusing Jeremy of perjury like they have done? They actually, so as Lisa said, they didn't write. They called. So she absolutely did. And in one of the FOIA requests, there's a stack of FOIA, right? It's a stack of it. But in the FOIA documentation that was allowed, that we were actually finally given for all this stuff, yeah, there's a communication referenced in there. And the communication is kind of interesting in the fact that you find out Lisa is talking about fence this, fence that. They all plotted, in my opinion, to try to get Hales put in jail. That's why they kept talking about how he would be put in jail right away. And in fact, there's a possibility that if he would not have sued, that God knows what they might have done. I mean, honestly, I don't know. I'm not saying they would have for sure or not try to, but who knows? I mean, I don't, again, trust them not to have tried something weird with that. But yeah, there's a giant FOIA document. It's a FOIA document dump. And there is a lot of crap in it. But in there, you have the documents that talk about Patty, which interestingly, they've been lying about lately. Again, I don't really understand why they're returning to that, except to make threats, you know, to talk about stand your ground. But there is this one letter. Let me pull it. Actually, this is not redacted. Let me see. I see it on the thing. And the only problem is it's not redacted off here. Let me read you this letter. Okay. This is to Dan Owen. All right. This is about a call from Lisa. It's not redacted. It's got a bunch of phone numbers and crap all over it. You know, instead of just redacting, I'm just going to read it behind it. I'm going to read it just straight through. This is from Lisa. It notes phone number and then Lisa Lee. I am unsure of where she is from, but is a fellow YouTuber, you know, because we're all fellow YouTubers, apparently. We all work, you know, just like if I were at a factory or something, I would be your fellow coworker. Isn't that ridiculous? And it's disgusted that this keeps happening too. It's redacted in family. You know who redacted is. They, unsure of who that is. So they said that so the anti-Hales ecosystem, they called themselves a they. Remember, they told us that if you use words like we or they, that proves that you are a conspiracy. That's what they said about us. I use they quite a bit, by the way, sometimes very incorrectly. You know, grammatically, if I know someone is a male or a female, I'm not supposed to use they, but you do anyway. And sometimes I just use it, just like we. I sound like Venom speaking, but I digress. They, unsure, it has it in parentheses, unsure of who that is, just paid $5,000 to get them a privacy fence, and redacted has moved the cameras up higher, more than 10 feet, to see over the fence, to basically stalk them and then use it as content to get views and money for himself. She's looking at so many Florida statutes that show redacted is breaking the law and no one is doing anything about it. She asked what we need to prosecute a case against him since all the others have been dropped, and stated whatever we'd need, she'd be sure to provide. Yeah, so they definitely are trying to put him behind bars. This is while he has, by the way, this is from November 21st, 2024, by the way. I explained we get cases from law enforcement and told her to contact them and file a report and provide all evidence to them. And if they felt like a crime had been committed, they'd forward it to our office and also provide all the documents / videos and information to us. She stated that she was unsure who to trust because he's on town council now, and that it's clear law enforcement hasn't gotten involved and hasn't done what they are supposed to do. And this family's suffering, being cyberstalked and harassed by the man. And she and others are tired of seeing this online content. That's the gist of the conversation. It was mostly the same things over and over. That was from that Katrina Sessler, that she's in on that. So that is that's one. And then there was a response to that comes later, basically saying, yeah, that's the way to respond to it. There wasn't a lot to the response, but in response to that, on a live stream, they said, yeah, we have contacted. We're just smart enough not to put it in writing because we know you'll FOIA it. So they did tell us absolutely that that's what they were doing. Crazy, isn't it? So anyway, let's continue. But yes, that's a good question. It's a very good question. So moreover, again, they talked about phantom exhibits not there, these. Moreover, unattached exhibits appear to contain information outside the four corners of the complaint the defendant relies upon to contradict plaintiff's allegations regarding his failure to enforce the protective orders. So the summary of argument. Now, the defendant says the motion to dismiss, the motion to dismiss, defendant's motion, right, here, I'll get it right in a minute. Here, rewind. Okay. Defendant's motion to dismiss should be denied for three primary reasons. First, the motion improperly relies on unattached exhibits that cannot be considered by this court under well-established 11th Circuit precedent. When ruling on a motion to dismiss, the court must generally limit its consideration to the pleadings and exhibits attached to them. That's true. If it's not there, how's that going to work? Defendant's unattached exhibits do not qualify for consideration under the incorporation by reference doctrine because they are not referenced in the complaint, not central to plaintiff's claims, and their authenticity cannot be verified. Second, even if the court disregards this procedural defect, plaintiffs have adequately stated claims under 42 U.S.C. 1983 that should survive a motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true, establish plausible claims for relief based on defendant's failure to give full faith and credit to the valid protection orders as required by, again, 18 U.S.C. 2265, and for violation of plaintiff's due process rights. Third, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for conduct alleged in the complaint. Defendant's conduct, refusing to recognize valid out-of-state protective orders and investigating whether plaintiff Hales committed perjury, constitutes investigative activity rather than prosecutorial function. Remember that. Whoops, stepping into the wrong battlefield, baby. You aren't an investigator, you are a prosecutor. So that is for which only qualified immunity is available. Moreover, defendant's conduct violated clearly established federal law requiring states to accord full faith and credit to protection orders issued by other states. So the argument. 1. Defendant's motion to dismiss improperly relies on unattached exhibits that cannot be considered by this court. Defendant Owen, motion to dismiss, suffers from the fatal procedural defect that warrants denial of the motion. It repeatedly references exhibits 1 through 3 to support factual assertions regarding state court cases allegedly filed against the restrained parties. But these exhibits are not attached. They're not there. Those are phantom exhibits. Again, that well established, as it said before. Legal standard for materials considered on a motion to dismiss under 11th Circuit precedent when ruling on a motion to dismiss under Federal Rule of Civil Procedure 12b-6. A district court must generally limit its consideration to the pleadings and any exhibits attached to them. If the parties present and the court considers evidence outside that, the motion to dismiss must be converted into a motion for summary judgment pursuant to Federal Rules of Civil Procedures 12d. And it notes, quote, the Federal Rule of Civil Procedure provides that a motion to dismiss shall be treated as a motion for summary judgment if the movant presents matters outside the proceedings. When a district court converts a motion to dismiss into one of summary judgment, the court is required to give, quote, notice to the parties and an opportunity for mutual discovery. That's interesting, right? So the 11th Circuit recognizes a narrow exception to this rule under incorporation by reference doctrine. Now, under this, the court may consider evidence attached to a motion to dismiss without converting the motion into one for summary judgment if three requirements. There's always some trifecta of requirements. One, plaintiff refers to certain documents in the complaint. Those documents are central to the plaintiff's claim, and the document content are undisputed, meaning the authenticity is not challenged. Here, there are no exhibits attached to incorporate, so that doesn't apply. While the 11th Circuit in, again, case here, held that, quote, when the exhibits contradict the general and conclusive allegations of the pleading, the exhibits govern. This principle only applies to exhibits that are properly before the court, such as those attached to the complaint or those that qualify under the incorporation by reference doctrine, which is also not the case here, because there's no exhibits. Defendants' unattached exhibits cannot be considered under 11th Circuit precedent, of course. So they, again, repeatedly reference Exhibit 1 through 3 to support factual assertions regarding state court cases allegedly filed against the restrained parties, but these exhibits, they're not attached. These unattached exhibits fail to meet any requirements for consideration under the 11th Circuit precedent. First, the unattached exhibits are not part of the pleadings. Federal Rules of Civil Procedure provide that a copy of the written instrument, which is the exhibit to a pleading, is a part thereof for all purposes. However, this provision is applicable to pleadings and not to motions. Defendants' unattached exhibits are not part of the pleadings. Therefore, they can't be considered on that basis. Second, the unattached exhibits do not qualify under incorporation by reference doctrine. The 11th Circuit has consistently held that for a document to be considered under this, it must be, 1, referred to in the complaint, 2, central to the plaintiff's claim, again, 3, undisputed in terms of authenticity. Defendants' unattached exhibits fail on all 3. So again, we've seen this argument already, so we'll jump forward. The 11th Circuit has emphasized that, quote, a document need not be physically attached to a pleading to be incorporated by reference into it. If the document's contents are alleged in a complaint, no party question. Again, we saw this, and it does not meet that. Okay. Now, consideration of unattached exhibits would require conversion to summary judgment. As they said, if this court were to consider those unattached exhibits, it would require to convert to motion to dismiss into a motion for summary judgment. That Federal Rule of Civil Procedure 12d provides that a motion to dismiss shall be treated as a motion for summary judgment if the movant presents matters outside the pleadings. When a district court converts a motion to dismiss into one for summary judgment, the court is required to give, quote unquote, notice to the parties and an opportunity for mutual discovery. The 11th Circuit has strictly enforced this requirement. Here, case law, the court held that if a district court considers materials outside of the complaint, it must generally convert a motion to dismiss into a motion for summary judgment. Such conversion requires notice to the parties and an opportunity for mutual discovery. Ooh, fun times. As again noted here, critically, such conversion requires notice to the parties and opportunity for mutual discovery. Failure to provide such notice and opportunity constitutes reversible error. Dun, dun, dun. Moreover, the 11th Circuit has cautioned against premature conversion of motions to dismiss into motions for summary judgment, noting that such conversions should not be used as quote unquote platforms for pseudo summary judgment motions at the time when the case is not at issue and the parties have not engaged in reciprocal discovery. The Supreme Court has similarly frowned on, quote unquote, frowned on, court-imposed heightened pleading standards designed to weed out non-meritorious claims before discovery. Now, defendants' reliance on unattached exhibits constitutes an implicit admission that the complaint states plausible claims. Now, the defendant's reliance on unattached exhibits constitutes an implicit admission that plaintiff's complaint states plausible claims that cannot be defeated without going beyond the pleading. Yeah, see, oops, you forgot to put them on there. Well, unfortunately for you in that argument, that's kind of, is that not stating, well, you'd have to go beyond everything contained in the four corners here to defeat it, huh? Under federal rules, under USCS, Federal Rules of Civil Procedure, R8, a complaint must contain, quote, sufficient factual matters accepted as true to state a claim to relief that is plausible on its face. A claim that is facial plausibility, sorry, it locked up for a second rolling. When the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. By relying on unattached exhibits to support his motion to dismiss, defendant Owen effectively concedes that the complaint on its face states plausible claims for relief. This is because if the complaint truly failed to state a claim upon relief could be granted, defendant Owen would have no need to rely on external evidence. The fact that defendant Owen felt compelled to reference external exhibits implies and reasonably infers that the complaint meets the plausibility standard to survive a motion to dismiss. Now, furthermore, defendant's attempt to introduce factual assertions through unattached exhibits runs counter to the purpose of Rule 12b-6 motion, which is to test the legal sufficiency of the complaint, not to resolve factual disputes. Defendant's attempts to introduce factual assertions without properly attaching supporting exhibits is an improper attempt to circumvent this rule. Now, I'm sure they'll be like, well, that was an oopsie on our part. Again, this is what you pay for. You pay for on the state level. And again, oftentimes, I mean, if you win straight up, that's something else. Oftentimes, friendly courts with prosecutors end up kicking cases, and you end up in an appeals court. Those appeals courts, they're the ones that really decide. So we'll see if that happens. Again, you never know, but it's always, this is one of the most interesting cases out there, because again, ultimately the standard here saying that they can do whatever they want it's a frightening thing to me. If I have a protective order and I go to Florida and some jackass decides that they're going to stalk me there and to do this or that, well, Levy County has told me it's not our problem. And that's a terrible precedent to set. So number 2, plaintiff has adequately stated claims that should survive a motion to dismiss. Now, even setting aside this defect, which we talked about, they've stated claims under 42 U.S.C. 1983 that should survive motion to dismiss. The legal standard for Rule 12b-6 motion to dismiss. When evaluating a motion to dismiss under Rule 12b-6, the court must accept all well-pleaded facts as true and draw all reasonable inferences in favor of the non-moving party. Again, case. The court considers the facts alleged in the complaint and exhibits attached to it. again, case. I like to note that case. A complaint need not contain detailed factual allegation, but must provide, quote, more than unadorned the defendant unlawfully harmed me accusation. Again, case. As shown supra, to survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim for relief that is plausible on its face, and a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. Now, plaintiff's first claim, failure to give full faith and credit to a protective order. Now, again, that's 18 U.S.C. 2265, creates a federal right enforceable through 1983. So Section 1983 provides a remedy for the deprivation of rights, privileges, or immunities secured by the Constitution and laws by persons acting under the color of state law. The full faith and credit provision for protective orders codified in 18 U.S.C. 2265 establishes that protective orders issued by one state, quote, shall be accorded full faith and credit by the court of another state, Indian tribe, or territory. Yes, I go to another state. That should even be a question. It disgusts me that we're even talking about a case where they decided to investigate the victim after a court. Again, you think about that. They questioned another state court. They went after them. They decided to have their own little tribunal in another court. That's crazy. Because, I mean, you think about that. Like, how many times have we seen protective orders that have been something that you really couldn't question without, again, you have a certain procedure that you typically see if you want to question a protective order. And I tell you what, this is not what you see. So they must be, again, quote, enforced by the court and law enforcement personnel of other state, Indian, tribal government, or territory as if it were the order of the enforcing state, Indian tribe, or territory. So you got to enforce it just like it happened in your state. It came from it. Statutory language creates a clear federal right to have protective orders recognized and enforced across state lines. The complaint adequately alleges a violation of this right. The complaint alleges that defendant Owen, acting under the color of state law as a Florida state official, refused to recognize and enforce facially valid protective orders issued by the state of Ohio. Instead of enforcing these orders, quote unquote, as if they were ordered of the enforcing state, as required by 18 U.S.C. 2265, Owen questioned the validity of two facially valid protection orders issued by the state of Ohio, and two, in an utter shockingly manner, defendant Owen tried to, quote unquote, turn the tables on Article 4, Section 1 of the U.S. Constitution itself by ignoring the Ohio protective orders and by his investigation into whether the victim, plaintiff Hale, had committed a crime, perjury, when obtaining the protective order in Ohio. That, again, should be very disturbing for people. You know, when you're like, hey, I need you to enforce this. Hey, wait a minute. Maybe we shouldn't because, well, what if? And the what if, I mean, that's insane. The complaint specifically alleges that Dan Owen requested to see something beyond the two facially valid protective orders issued by the state of Ohio. He asked to see petition for protective order that Hale's filed in Ohio to obtain the protective order, stating he wanted to, quote unquote, see if Hale's committed perjury in the petition. Defendant Owens' conduct, including ignoring the Ohio protective orders, directly contravenes the mandates of the U.S. Constitution and statutory requirement that the protective orders be given full faith and credit without such a re-examination. Now, under 18 U.S.C. 2265, a protective order from another state must be enforced as long as the issuing court had jurisdiction over the parties and matter under the law of the state. And reasonable notice and opportunity to be heard was given to the person against whom the order was issued. The statute does not permit officials in the enforcing state to investigate the truthfulness of statements made in obtaining the original protective order. Yeah, this is essentially, you think about how crazy that is, because they decided that they would go in and they would investigate an already decided matter. Not only is that a waste of resources, but that shows you something is inherently wrong there. People that are doing that, either they have some kind of disgusting bias where they want to do damage to someone for some quote unquote unknown reason. I think we might know the reason there. Makes you go, huh, though, right? The result of Defendant Owens' action was a complete 180 from the standpoint of Levy County law enforcement. Defendant Owens' inquiry into whether or not the protected person, Mr. Hale, committed the criminal act of perjury had a chilling effect on any attempt by Levy County law enforcement to proceed with analyzing whether or not there was a probable cause to arrest the Ohio resident for violating the Ohio protective order. Or respondents, rather. I said resident, but respondents, rather. I was like, wait a minute, that's not the right word. Respondents. Yeah, that's right there. You think about that. If a prosecutor, I was told this by a sheriff's department, if a prosecutor is not going to press charges, they're not going to waste time going and arresting somebody, because it takes time, it takes resources. Why should they bother for no results at the end of it? I mean, that makes sense, right? So the police, they're being told that their investigative efforts, they've already been decided on the back end. In fact, a police officer, they made a statement about that, about them being cautioned not to. So why should they respond at all? Which is a dangerous precedent to set. Now, regarding Defendant Owens' claim that, quote, the Florida Enforcement of Foreign Judgment Act must also be considered, this is absolutely contradicted by none other than the Attorney General for the state of Florida himself. Holy crap. Florida Attorney General, opinion number, they give the opinion, issued September 1996, states that the provisions of state law, such as the enforcement of foreign judgments acts, are inapplicable to the enforcement of foreign protective orders issued in compliance with the VAWA. The Florida Attorney General opinion, again, got the number there, addresses enforcement of foreign protective orders under the Violence Against Women Act, or the VAWA, or VAWA. I usually don't ever say it that way. It states that foreign protective orders issued in accordance with 18 U.S.C. 2265 are enforceable by law enforcement agencies in Florida without the need for registration or recording. The opinion emphasizes that such orders must be enforced as if they were issued by the enforcing state, provided that the issuing state has both personal and subject matter jurisdiction, and the respondent received reasonable notice and an opportunity to be heard. Quote, with the enactment of VAWA, Congress has recognized that DV constitutes a national problem that transcends state lines. The Act provides a critical component in the protection against DV by mandating recognition and enforcement of foreign protective orders. Now, Title 18 U.S.C. 2265, it provides that any protective order issued that is consistent with subsection B of this section by the court of one state or Indian tribe, that would be the issuer, shall be accorded full faith and credit by another court, or by the court rather of another state or Indian tribe. That would be the enforcer. So if the issuing state, if they put one out, enforcing state, they need to enforce it as if that order came from them. In order for the full faith and credit provision of 18 U.S.C. 2265 to apply, again, the Act requires state issuing protective orders have both a personal service. Again, they go through, again, subject matter jurisdiction, Here we've already read that part multiple times, it's stated differently. But a protective order is defined in 18 U.S.C. 2265 as including any injunction or other order issued for the purposes of preventing violence or threatening acts of harassment against or contact or communication with physical proximity to another person, including temporary and final orders issued by civil or criminal courts other than support or child custody orders, whether obtained by filing an independent action or as pendant light order in another proceeding, so long as a civil order was issued in response to a complaint, petition, or motion filed by or on behalf of a person seeking protection. A review of the legitimate legislative history surrounding the enactment of VAWA indicates an intent to provide protection for victims of DV crimes across state lines. A congressional committee report discussed the Act states the VAWA makes protective orders issued by one state good in all other 49 states. Under then current law, a spouse who obtains a stay-away order in one state may lose the protection of the order if it crosses state lines. So the committee believes that this makes sense, right? If you have a stay-away order, it doesn't become invalid because I go to another state. That's absurd, right? Under the VAWA, you can see how that applies. And again, this goes for all protective orders. I mean, that makes sense, right? And this is an opinion that was handed down that runs contrary to what they were trying to say, that, well, we can do whatever we want pretty much. The committee believes that the actions constitute an appropriate response to the problem of DV, which, because of their interstate nature, transcends the ability of state law enforcement agencies. Thus, it is not a radical expansion of the law to require one state to enforce the stay-away order of another. It is a fundamental rule of law that statutes are to be construed to give effect to the intention in legislative body. Thus, in order to give effect to the expressed intent of Congress, I am of the opinion the VAWA requires that a protective order issued by another state or Indian tribe in accordance with, again, 18 U.S.C. 2265, be treated and enforced as if it were a protective order issued by a Florida court. That is very important right there. Again, Article 4, Section 1 of the U.S. Constitution states, full faith and credit shall be given in each state to public acts, records, judicial proceedings of every other state. And the Congress may, by general laws, prescribe the manner in which acts, records, and proceedings shall be provided and effects thereof. The provisions of 18 U.S.C. 2265 constitute implementation of authority granted to Congress by Article 4, Section 1 of the U.S. Constitution. Congress has specified that protective orders of one state consistent with the provisions of the VAWA are to be enforced in any other state. Federal acts does not make such enforcement contingent upon registration in the enforcing state or require judicial review. So look, there is no review that's needed here. Why the fuck is Dan Owens reviewing? To enforcement of foreign DV protective order law enforcement. Ordinarily in Florida, an individual wishing to enforce a foreign judgment, they must record the judgment with the clerk of the circuit court. They, again, All of this was done as Hales was told. Hales and George, they went in, they informed, they did all of that. They made sure everyone was aware. Under the Florida Act, notice must be provided to the individual against whom the judgment applies, and such judgment is not enforceable for 30 days after the mailing of notice by the clerk. If the provision of Florida Act were applied, the target of the order would be notified of the filing by and the location of the DV victim, which would be hindered by which would hinder the victim's ability to keep their location secret. As noted above, nothing in the VAWA requires registration of foreign protective orders in the enforcing state. So while there may be an advantage in registering that, requiring registration, this is important too, because it's insane the way that stuff was noted. Requiring registration could leave victims unprotected and vulnerable for a crime as they enter a new state until the time they become aware of and satisfy registration requirements. Yeah, if you have a requirement saying, well, I got to register in 30 days, you know, what would that mean? That would be insane, right? So they're laying down, again, this opinion makes a lot of sense. This is how laws should roll. And Dan Owen, again, his argument runs very much contrary to this. The Federal Act preempts any registration requirement by mandating that the foreign domestic DV protective order be enforced as if it were an order of the court of the enforcing state. Thus, provisions of state laws such enforcement of foreign judgments acts are inapplicable. So, you know, when he was saying, hey, wait a minute, we need to look at the Enforcement of Foreign Judgments Act. Well, interestingly, that's inapplicable. And it says that. Whoopsie. So his reliance on that argument to say, well, what I did, that's fine. Yeah, no. In Florida, a temporary or final judgment or an injunction for protective order against DV is valid and enforceable in all counties of all states. Law enforcement officers are authorized to use arrest powers under Section 901.15.6 Florida statutes to enforce a DV injunction. Therefore, in accordance with the mandate that protect foreign protective orders issued in accordance with the VAWA be given full faith and credit of enforcement in the same manner as state's protective order. I'm in the opinion that local law enforcement officers should enforce foreign protective orders as if they were an order of the court in the state. Such orders, like state DV injunctions, are enforceable throughout the state. While legislative action to clarify these issues may be helpful, enforcement of foreign protective orders is not contingent upon passage of such legislation. So I think that's very clear. Now, plaintiff's second claim, violation of substantive due process rights. So the allegation in the complaint points to failing on the part of the defendant Owen by, inter alia, ignoring the Ohio orders altogether, since questioning how they were obtained. Plaintiffs have not alleged procedural deficiencies in the process used to deprive their interest, if any, in the enforcement of the Ohio orders. This means that their claim is best considered irrespective of process as a deprivation of substantive due process rights. Yes, you deprived me of due process by ignoring the validity of the Ohio protective orders and instead initiating an investigation into the truthfulness of plaintiff Hale's statements and obtaining these. Been going. I think I heard somebody drop into my place here. I think they're backstage.
I am. I'm here.
Dun, dun, dun. I like
Dun,
that.
dun,
I actually,
dun.
you know, I like this. Where is it? I like all of the, where they're talking about the
Isn't this amazing?
Yes, because they were heavily reliant on that idea. He was
Oh,
like,
yeah.
I get to investigate because of this.
Oh yeah. Oh yeah. This is such an epic smackdown. I was just recording a video actually of reading this and giving my thoughts on it. I was doing that. I was going to try and get it up for you to redirect to after this. I don't know if I can. I still have editing to do, but I wanted to drop in and say, "Oh my God."
It's good, isn't it?
It is. Everyone says I'm too loud. Okay, hold on. Am I too loud?
I don't hear it. I hear you at the same level that I.
Do you like my winter background? Check out my winter background. Look at this.
Oh yeah, I saw that from the.
I've been playing around with OBS, and I'm having fun with it. Yeah. But yeah, I finally, can you believe I learned how to use OBS? But anyway, this is unreal. This is my favorite, my absolute favorite filing ever.
I love this case because.
Me too.
Yeah, I mean, you know, it's chilling argument that Dan Owen made. I've tried to tell people that over and over. If you missed his argument, really look at it. And I don't care if you are totally against Jeremy Hales, if you think he's the worst person ever. If you read that and you think that a guy telling you, I can do whatever I want, I can investigate whoever I want, and if you got a problem with it, and I can tell the police not to arrest somebody if I want, if you think that's okay, we've got a real problem.
Well, and here's the thing that's crazy to me. I didn't realize this till like the second time I read this through. This guidance that we're reading right now from the Attorney General's office in Florida is from 1996.
Yep.
We call that well established. And I did some research. I found out that guidance from the Attorney General does not expire. It does not expire. It does not get overridden. It doesn't get it's still there. So you've got Dan Owen and his attorneys from the Attorney General's office arguing against themselves. They're arguing against their boss. They're basically saying, we disagree with the office of the Attorney General as lawyers for the Attorney General. It's so embarrassing.
What this points to as well is it points to the quality of state representatives. Again, you run into some pretty corrupt courts ruling for their pals and stuff. If we could slide all of that aside and look at what really represents us, my God. Oh.
Really, after I read this, my initial thought was, oh my God, they should settle and fire Dan Owen.
Yeah, for real.
Settle now and fire this man, get rid of him, because he has violated federal law. He has spit in the face of the Attorney General of Florida. Just let it go. Just let this one go. And you know what else, Tug? I was thinking,
what's that?
Jeremy, this is the best case that we have in the Hales thing. It is. It's the best case because it's the only litigant in the case that has the money to make him whole. They have done to Jeremy Hales and George, by the way, is make it so that they had to spend all of their money on civil remedies when there should have been a criminal remedy.
Yep.
And they should not have done this. If Dan had just done his job, Jeremy and George would not have had to spend $450,000 on all this civil stuff that they are trying to do to stop it. If the law had just stopped it when they were told they should, we wouldn't have this problem.
Right.
So I think they are liable for every fee, every attorney fee, every case he's had to file. Oh no, Jeremy would definitely settle this one. Oh, believe me, yes, he would. He would.
Yeah.
If the state wants to settle, they're basically going to say, okay, we fucked up. We're going to give you $2 million or whatever and call it a day.
And the state also, if you don't like settling, they will drag their feet forever. They will, we will be looking at 8-9 years of foot dragging bullshit, because that's what they do. You see it in actions against law enforcement. They do everything that they can, and God, they're awful. But they do. Once they think that they're going to have problems, they will try to settle the case. And
they should settle this case. This is no good for them. It's not. This is no good. No, and it would be way more than $250,000. He spent $450,000 already on attorney's fees to fight these people off. So it's going to be $450,000 or more, and it better be more, because he also has deprivation of rights. Deprivation of rights is a big deal. 1983 cases, when you have a good case, You're talking millions of dollars. Okay. I've seen these before. I've seen 1983 cases win before. Sean McMillan, one of my favorite lawyers, does 1983 cases all day long against CPS and hospitals who take children wrongfully from parents. He always gets $2-3 million. When they settle big because they know deprivation of rights is a big deal. This is a big deal. And he can show, not only can he show lawyers' fees, but he can show that he lost revenue, millions. He has lost millions of dollars. It's a multi-million-dollar case, Todd.
Oh yeah, for sure. And on top of that, you know, we are talking about Dan Owen stepping outside of what he's supposed to be doing, you know, and again, as it says, he started investigating. What exactly was he doing that for? Why exactly is he investigating Jeremy Hales?
I am working on that. I'm actually really close to finding out why. I think I know. And it happened way before any of this stuff happened with Lynette and John. That's the crazy part. The thing that turned Dan Owen off to Jeremy Hales was something that prejudiced him. And I believe I believe he biased himself in writing. I believe he put it in writing.
Yeah. I know. I know what you're talking about there. I remember this now, but I'm not going to note it until you find what you want.
Let's not talk about it I'm going to be general about it and vague about it because I have some work to do on it. But I do believe that Dan Owen himself or someone who works in his office speaking on his behalf put it in writing before the Lynette and John stuff even happened.
Woo, baby, you know.
Yeah,
Hey,
sure I can.
Let me check what that is.
Sure I can. I think I found the smoking gun on this, guys. I'm looking for it and I'm on the case. But I do believe that there was a biasing moment that happened. And you guys remember all the kerfuffle at the town with Jeremy. And if Dan goes down, he will go on my wall for sure. For sure. I'm just going to stay vague about it because I'm still in the process of getting the goods. But I do believe that he has been holding out in FOIA requests. There are things that he has put in writing that he has not disclosed, and it will come out in discovery. And somebody asked in the chat, am I going to write about this for PJ Media? You're damn right I will. You're damn right I will. Now, this has crossed the threshold into what I consider to be national news. You're damn right I will. This right here, this whole case, I'm going to start writing about for PJ Media. Yep.
Right. The kids aren't here, so I was like, what in the heck?
Was there weird noises or something?
Yeah. I was like, what is that? So I went to check, you know.
All right, listen, here's what I'm going to do. So I need to go and edit this video because I'm trying to get it done in time to put up for you to redirect afterwards.
All right. Do me a favor, when you finish, redirect. When you finish, just instead of tech, because you know how I am about watching.
I'll pop back in.
Yeah, just tell me. You know, I have some pages. I don't have an army of pages left, so go get it done.
All right. Yeah, no, it won't take me long. So I'll go get it done, and then I'll pop in and let you know that it's done. Okay. All right. All right. Bye.
Later. Yeah. See, I mean, it's an amazing case. Again, when you go through this thing, this is probably, you know, there are interesting cases that are out there in the ecosystem. Don't get me wrong. I mean, some of them, because of the players that are involved, I think they're interesting cases. But this is a fascinating case because, like Megan said, I mean, this has had a huge ripple effect that ended up costing Hales quite a bit. You know, because if they would have gone in, they would have enforced. They wouldn't have. I mean, they went beyond not enforcing. They encouraged harassment by this party, which is insane when you think about it. So, the plaintiff's second claim, violation of substantive due process rights. The allegations in the complaint point to the failing on the part of defendant O by ignoring the Ohio orders altogether, since questioned how they were obtained. Now, plaintiffs have not alleged procedural deficiencies, again, in the process used to prove their interest, if any, in the enforcement of Ohio orders. This means that their claim is best considered irrespective process as a deprivation of substantive due process right by ignoring the validity of Ohio protective orders and instead initiating an investigation into the truthfulness of plaintiff Hale's statements and obtaining them. Defendant Owen effectively nullified the protective order without any process whatsoever. That's what he did. I mean, exactly. And that's how the police took it. Again, I think there is another email too. If you look at the response, I believe that there is another one. I believe they are hiding another one. It is important to note that while the Supreme Court has held that individuals generally do not have constitutional right to have someone else arrested for a crime, the principle does not apply to protective orders that are ignored. This is deliberate indifference toward the violation of an individual's constitutional rights. By ignoring the protective order rather than enforcing it, Defendant Owen violated the clear statutory mandate. Substantive due process protects individuals prescribed deprivations of life, liberty, and property, no matter the process employed by the state. Again, you can see that case law, my brain today, man, the substantive due process state law is a source of rights which may not be taken away under any circumstances. This is not a case where the alleged violation is simply that an order was issued and law enforcement ignored calls to arrest someone. Rather, Defendant Owen affirmatively and deliberately chose to ignore facially valid Ohio protective orders. Yes, this is a good note too. This isn't a case where they go and law enforcement's like, nah, I'm not going to do anything about it. Instead, Owen, he deliberately chooses to ignore the protective order. He wants to question it itself, and it poisons the whole damn well. Now, under this, Defendant Owen's inaction with regard to Ohio orders means this court could easily infer from the facts alleged that Defendant Owen was aware that Mr. Cook and Miss Preston posed a significant risk of harm to plaintiffs vis-a-vis his knowledge of the order, yet he acted indifferent to that risk by choosing not to act at all regarding the Ohio order, other than investigating whether Mr. Hales committed perjury. That's right. That's a frightening affair, too. He ignores the fact that another court said that they pose a potential significant risk of harm. You know, we have an order where somebody has pulled a pew-pew on another person, which is insane. And they're like, no biggie whatsoever. It's nuts. I mean, when you think about it. So again, case law. An omission evinces the deliberate indifference toward the violation of individuals' constitutional rights may amount to an act that causes the violation. Also, case law holding that the plaintiff sufficiently pled deliberate indifference against two supervisors who, although they, quote, could have investigated the complaints, they did nothing for a considerable period of time. Now, Defendant Owen argues that he's entitled to absolute immunity as a prosecutor. However, this argument fails because investigating whether Hales committed perjury and obtaining a protective order is an investigative function, not a prosecutorial function. Prosecutors only have qualified immunity when performing functions not associated with their roles as advocates for the state. Quote, the actions of a prosecutor are not absolutely immune merely because they are performed by a prosecutor. That's right, Dan. Just because you're an effing prosecutor doesn't mean that everything that you do is somehow immune from prosecution. That's not what it means. It shouldn't mean that anything that you do prosecuting, honestly, you shouldn't have that, but unfortunately they do. But when you change up what you're doing as a prosecutor, yeah. Now in Buckley, the Supreme Court emphasized that a prosecutor is not an advocate before probable cause exists, and that investigative functions, such as searching for evidence or cooperation, are not entitled to absolute immunity. The Supreme Court could not have been clearer. Prosecutors are not entitled to absolute immunity for their actions in giving legal advice to the police. And they took it as legal advice. They absolutely did. You saw how they responded, which is a beautiful argument there, because the police were like, we shouldn't do this. And he wrote it into a report. 100% points back there. That means that Owens' investigative actions, such as advising Levy County Sheriff that Owens needs to evaluate the validity of a foreign protective order because he suspects that the protective party committed perjury in obtaining the protective order before any judicial proceedings began, fall outside of the scope of absolute immunity and are instead subject to qualified immunity. Mr. Owens' inquiry into the merits of a foreign protective order under the VAWA, absent a specific violation, is an investigative act and would generally be protected by qualified immunity rather than absolute immunity. The 11th Circuit amplifies the Supreme Court on this issue, noting, quote, on the other hand, prosecutorial immunity does not apply when the prosecutor acts outside the ambit of activities intimately associated with the judicial process. Generally, the Supreme Court has made it clear that prosecutorial immunity may not apply when a prosecutor is not acting as an officer of the court, but is instead engaged in certain investigative or administrative tasks. These activities include conducting investigative work before arrests, making statements to the press, and providing legal advice to police regarding pre-indictment investigation techniques. So the defendant is not entitled to either absolute prosecutorial immunity or qualified immunity. Number 3, defendant is not entitled to absolute prosecutorial immunity. Prosecutors enjoy absolute immunity only for activities intimately associated with the judicial phase of criminal process. This immunity extends to a prosecutor's acts undertaken in preparing for the initiation of judicial proceedings or for trial, and which occur in the course of his role as an advocate for the state. A prosecutor enjoys absolute immunity from allegations stemming from the prosecutor's functions as advocate, but has only qualified immunity when performing a function that is not associated with the role as advocate for the state. Now, the conduct alleged in the complaint, refusing to recognize the validity of protective orders issued in Ohio court and investigating whether plaintiff Hales have been truthful when obtaining those orders, falls squarely within the category of investigative activities for which prosecutors receive only qualified immunity. Only, baby. Defendant Owens' email explicitly states his intention to investigate plaintiff Hales committed perjury in his petition for protective order. This investigative function is not entitled to absolute immunity under well-established precedent. Similarly, God, it keeps rolling backwards, you see that. In the 11th Circuit, when a prosecutor obtains and reviews suspects' public driving license records, such conduct may be properly characterized as investigative rather than prosecutorial. Defendant Owen was not acting as an advocate for the state in a judicial proceeding. That's right. He was not, but rather he was investigating potential perjury. Now, Owen concedes he was only investigating, quote, Mr. Owens sent an email to Levy County Sheriff's Office that shows he was investigating the Ohio court's jurisdiction over. So again, it does note by their own defense that he was investigating. So it's awesome that when you go with this argument, which absolutely makes sense here, that he's eliminating his own claim. When they use the words like, oh, he was investigating this, well, okay, what function was he doing? All right, well, that should eliminate the claim of absolute immunity, and it should slide this under his claim of qualified immunity, which, again, you can shoot down too. So, defendant Owens Request for the petition filed by plaintiff Hales to determine if he committed perjury is an investigative function. The email demonstrates that defendant Owen was not acting as an advocate in an ongoing judicial process, or proceedings rather. Now, this not a qualified for the qualified immunity. Now, even if defendant Owen is not entitled to absolute immunity, he argues he is protected by qualified immunity. So he gets the qualified immunitas. That's he's like, well, if I don't get one, I should get the other, right? I should get the other. Now, on this, the problem, see, here's a problem too. Like I said, if you read the police, their statement, I believe that there is another email. I believe that when you read over what they're stating, they are sitting on something. Now, can they do that? Yes, they could be doing that. Absolutely. They could do that under saying that they have a case open or all kinds of, again, they do some pretty jacked up stuff, you know, to keep you from seeing exactly what kind of screw ups they participate in. So could they be doing that? Absolutely. So anyway, qualified immunity. Even if defendant Owen is not entitled to absolute immunity, he argues that he's protected by qualified immunity. This argument also fails. Qualified immunity shields government officials from liability only when the conduct, quote, does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Now, defendant Owen's refusal to recognize the validity of protective orders issued by Ohio court and ignoring the same violates clearly established federal law. That is important too. Clearly established is an important portion of all of this, you know, because courts, sadly enough, when they decide to take on officials, whether that's, again, police officers, prosecutors, whatever, they need something to reference back to otherwise. So again, let's see, under federal law, any protective order issued that is consistent with, again, subsection B of this section by the court of one state, I'm just going to go with state instead of all of that, shall be accorded full faith and credit by the court of another state and enforced by court and law enforcement personnel of the other state as if it were the order of the enforcing state. Again, very easy to understand in our law. If a state issues a protective order, it needs to be treated like it was issued in another state, the enforcing state. They need to treat it just like that in enforcement. They don't need to pretend that there's some difference there, because otherwise we would have a problem. There would be a gap in that, and victims would suffer because of it. So the full faith and credit clause and its implementing statutes require states to respect and enforce the valid judgments of other states and certainly not ignore them. This means that a reasonable official in defendant Owen's position would have known that refusing to recognize valid out-of-state protective orders violates federal law. The federal statute clearly mandates that protective orders issued by one state must be accorded full faith and credit by other states. This is not novel or ambiguous legal principle, but rather a well-established requirement under federal law. Further, defendant Owen's investigation into whether plaintiff Hale committed perjury when obtaining the protective orders in Ohio exceeds his authority. If defendant Owen had concerns about the validity of the protective orders, the proper course would have been to challenge them through established legal channels. Yeah, not backroom emails over to the sheriff's department and try to do some backhanded BS. See, that's why, again, I think it's a real interesting quandary that we're seeing with Ohio and the protective order. because if we have the guy that was on the other side of that email, remember, you have one suit here and you have one that LP seems to think is going to show up as a witness for her. It really starts to look hinky when these people, they are questioning this protective order. They are going out of their way not to enforce it, and they have done that from go. You have a prosecutor telling people, hey, investigate this and see if this was obtained properly. Shoot this down, wink, wink. And on top of that, again, the police saying, well, there seems to be something here that he seems to be telling us not to enforce. So, again, he could have gone through established legal channels, not to refuse to ignore them and launch an independent investigation into potential perjury. So, conclusion, for the foregoing reasons, defendant's motion to dismiss should be denied. Defendant's motion improperly relies on unattached exhibits that cannot be considered by this court under well-established 11th Circuit precedent. Even if the court were to disregard this procedural defect, plaintiff have adequately stated claims under 42 U.S.C. 1983 that should survive a motion to dismiss. The complaint contains sufficient factual allegations that, when accepted as true and viewed in the light most favorable to the plaintiffs, establish plausible claims for relief based on defendant's failure to give full faith and credit to valid protection orders as required by 18 U.S.C. 2265 and for violation of the plaintiff's due process rights. Furthermore, defendant is not entitled to either absolute prosecutorial immunity or qualified immunity for the conduct alleged in the complaint. Plaintiff's claims are well pleaded and supported by sufficient factual allegations to survive a motion to dismiss under Rule 12b-6 of the Federal Rules of Civil Procedure. Now, that said, should the court grant Owen's motion, it should do so without prejudice to afford plaintiffs an opportunity to amend to address any perceived defect. You always put this here too. This is standard form. I always love it. I saw one of the ecosystems, the morons over there. They read, I can't remember which filing it was, but it had this stated on it. And they pretended like this was some kind of, they're afraid that it's going to be shut down. And I was like, no, idiot. Didn't AI tell you when you were utilizing it, to make up and pretend that you're all lawyers? They are very well lawyers, apparently. But didn't it tell you that maybe you should add in something like this? Because it kind of blew my mind when I saw that. Oh, my God. Speaking of lawyers, by the way, so this is the end of the, let me make sure there's nothing attached to the last page, too. On the last page too, we don't have anything. One second, I'm gonna clear my throat. We don't have anything hinky on the end of this, by the way. Sometimes with certificates of service, for example, when it comes to LP, JC, BBB, all of those folks, sometimes you would end up with something odd on the end of filing. With this, you did not. You did not at all. So just saying it's not there. Now, I did want to mention one other thing tonight. And this was something that kind of struck me as, an interesting argument, all things considered. I don't know if you guys, well, let's just go with this. If you missed out on some of the fireworks that happened a few days back, we played a clip, by the way, of this on Rumble. So I'm going to refer to something. And if you want to see the actual clip of it, you can go and refer to our last Rumble stream, with Megan Fox. But we had 2L decide they would bring on a guest. They decided that they would bring on a 19-year-old, which is related to one of the 2L members, and they would give their opinions on everything that's been going on here, right? In this case. Well, when they did, they decided to call Jeremy Hales a PDF file. And the damage control, it started in pretty fast, right? I mean, we were told quite a few things about that. We were told, at first that, they rebuked it. They said, no, like that wasn't actually the thing. He couldn't understand, because they blamed it on autism, which, again, as I said, why bring on somebody if somebody is not functioning at the level that they could understand something that's going on? Why exactly? Here, let me bring this up in front of you. Okay. Why exactly would you bring them on a panel to talk about something? Why would you put them in that situation? Why would you give them the ability to influence folks? And well, apparently, in response to that, we have a new type of spin. This new type of spin is that Topher, who said that, number one, is entitled to his own opinions. That's right. It's an opinion. When you call somebody a PDF file, that's apparently just a personal opinion or a tirade or whatever, and is not actionable by law. Now, this is one of the dumbest things I have ever heard, because the entire federal one case is predicated on the idea that, yes, you can indeed have some action that is caused by labeling someone a PDF file. Now, it wasn't some random person in the chat that stated this either. It wasn't anything like that. You had these idiots. They had been telling, this person over and over, he's filming over fences. He is trying to creep on this little child. And of course, that person, they formed an opinion off of that. Unfortunately, that is actionable. In fact, what's funny is there is a filing by none other than Paint Chips, another person in the anti-Hales established group. Now, when he filed, he said that this was a life-ruining accusation. This type of thing, it is the worst thing that could ever happen. And accordingly, just the mention of that by somebody, they should be held accountable and for quite a bit of moolah. So I thought that this, we're not allowed to have opinions. Yep, you sure are. Oh my God. What a bunch of morons, What a bunch of idiots. They played this game is so funny. And we'll go into more depth on this tomorrow. But it kind of blew my mind to see how this was framed. Considering, again, we have seen 3 types of damage control over this particular statement, and we have seen it. It hasn't even been a week. First of all, they had, again, my favorite is he doesn't understand, like I was going over. That is my favorite damage control. He doesn't understand. He doesn't understand words he says. Now, when you listen to their claims and he draws inference stating, oh, well, these people are claiming that he's doing X, Y, Z to little kids, and he calls them a PDF file, then yeah, I think he understands the connotation there. I think he very well understands that. That fell flat on its face. So the next damage control was indignance. Oh my God, Jeremy Hales, he's the monster. And that poor 19-year-old, he is somehow the victim. Not the victim of the idiots that brought him on the show, by the way. Oh no, that wouldn't work out. Nope. He is the victim somehow, according to them, of one Jeremy Hales. Isn't that amazing? And now Now the newest way of deflection is actually you can't do anything about it because it's just opinion. Now, these are the people who think that they are smart enough to pass the bar and to give legal advice everywhere. They think opinion, because if I label something that I state as just an opinion, it depends on what I state. There are certain things I am allowed to have opinions. However, when I start making statements about somebody being, again, certain type of reputational damaging, let's say, things, that goes beyond the pale. So let me see where Megan is about redirect, because I'm going to let me message her real quick. I'm going to tell her you're getting into super chat, so better have that redirect ready soon. Give me, well, a little bit. It'll take a few minutes, but still. Okay, hitting supers. Letting you know for the redirect. All right, so let's do some supers, and then Megan has a video that is coming up. It will be dropping after this. I would link it now, but it's not finalized. She's working on it right now, so hopefully she does get it finished before we finish up. Fallen Hero, thank you for your gifted membership there, by the way. Thank you, Fallen Hero. I hope you are doing fantastic, by the way. And as always, it is good to see you. I very much appreciate you, my friend. Wheat Toast, the Wheat Toast West Coast, also drops that gifted membership. Thank you. Did you like my my new toast, by the way? Did you like the Christmas toast? Isn't he pretty? Look at that. Oh man, look at him. He's so happy. Isn't that lovely? I kind of like him. Thank you. Thank you, Wheat Toast. Appreciate you. Wheezy. What's up, Wheezy? Thank you for the 16 months. And just like that, you blink and 16 months pass by. That's true, man. It's amazing how fast some of this, it seems to flow by, I mean, when I started covering all of this stuff too, I didn't think that this would be something that, would require more than maybe a week of cover at most, when you talk about everything coming in. But I never imagined it would balloon into this insanity. And again, just the hype. Next Tuesday, you be here as often as you can, I would ask. But if you have to choose a day, like next week, you definitely need to tune into everything next week, because it is going to be absolute crazy. You're going to love it. Wheezy, thanks for the 20 there too. Thank you. Just a little something for the Tuglets. Well, thank you. I appreciate it. As you'll notice in the house, it is very quiet today, by the way. You notice there is no sound of the little ones running around. It's very weird to me. It kind of weirds me out, because anytime I hear something random, my earphones, they amplify sounds on that. I keep thinking, what is that? I hear water running or something. It's very weird.
Right, it's rendering. It'll be up soon.
It'll be up soon. Is it already? Is it processing on there now?
It's yeah.
Okay.
Well, it could take a while. Damn it. Well,
I'm slow.
If it doesn't work, I just figured you'd be slow enough. If it doesn't work, that's okay. I can always.
I even threw in some. Hey, did you see the deflection, by the way? Now for
what?
I was mentioning this earlier. So the Topher saga.
Okay.
He called him that. Yes, the newest. The newest item. Let me pull up this statement here, just so you can see this on your screen.
You forgot to send me the transcript, by the way. I still want it.
Oh yeah, I'm just I must have spaced it. It has been a crazy day.
I know. I'm not.
Yeah.
I know. You know, you're holding on to all my gifts from the chat too. I mean, it's a whole
I'm
thing.
now I'm wearing them and stuff. You know.
Yeah,
That's
I
what
bet
I'm
you
wearing.
are. And now that
I am.
I've mentioned
I'm
it,
eating
you'll
those chicken
never send
skins.
them to me. You'll never
I'll
send them.
never.
And
I'll never.
that's the thing.
It'll actually be
No-
retaliation. I'll dig a
Chat.
hole in the yard and set them on fire. No, I would never do that. I would only do that to chicken skins. No, actually, I'm kidding. Those chicken skins were good, by the way. I know you would
Were
try
they?
some, but I'm eating.
Well,
them.
I would love to try some, and they were supposed to be for me.
Well, I will spiritually, give you know.
Did you get my short? I sent my short to you today. It was so funny.
I saw that.
I had
It
so
was
much
funny.
fun with that short. Oh my God. I'm getting ready for the Mugiversary. So I'm
That's
collecting clips
Yeah.
of things over the 2 years that we've been doing this. I
No,
can't
those
believe
chicken
it's been
skins,
2
I
years, but
tell you
I
what.
swear to God, I'm telling you right now, if you don't send me my gifts,
I'm not sending.
if you don't send me my gifts
It'll
from
be,
the chat that were for me,
It's been
we
several
we will not
hours and 15
we will not
years.
see 3 years.
I
We
will
will not.
never send
3 years will not
you
happen.
anything. You know what's funny is there's a little stack of whatever's there. It just sits there. But
You need
the
to put it
chicken
in a-
skin thing was labeled for me.
in
So
a
I was like, what?
box,
It's for who
fuck's
now?
sake, put it in a box and send it.
No,
I will
dude.
text you. I will send you the money.
No.
Why
It ain't
no?
about money. It's just about, why? Because every now and then you have a weird outburst like this, and it kind of amuses me. I guess I do need to see it though, because I
You
am. I
do.
guess, being
It's
into the
been
chat.
2 years. Listen, for our anniversary, please.
whatever.
All I want from you is to send me
what
the
is
things that the
time?
chat sent for me.
What is time? I mean, really.
Listen,
you
how's
know?
the bench? How is the bench funds going? I feel like the bench funds are
Oh,
not
I
going
didn't get
so.
to show you this. This is amazing. Let's pull this up.
Where
We
are the
had some-
bench bucks tonight, chat?
Actually, we need to pull this up too. I haven't gotten to show you this. So, with the memorial, we actually had some great feedback. You missed out on this part. We had things like, I loved it. Yeah. Amazing. And I guess Megan and Tug, I don't know whose channel they're on or whatever, but they're talking about the memorial bench. I was like, my God, it's none of your business. Nobody's business, man. He also had wonderful ones like Megan and Tug, your leader, your boss. He stole the memorial. It's on his property. It's not there. I don't know.
Video proof? Are they talking about that weird grainy footage of someone's taillights?
They said that they have video of him, George, and other people, but they wouldn't release it now. And I'm like, yeah, that tells you it's not true.
They don't have it. They don't have it, or they would have. I want my 2 leggings. Yes, JD 5061.
No,
That's
no,
correct.
I'm wearing those right now. They're very warm. Thank you.
No, I'm wearing leggings right now, but not ones made by the chat. Look, chat.
I'm
Well, you
wearing
can't
them
see.
right now.
He's got show my camera so they can see my leggings. Come on,
Yes,
you've got
I
the
gotta
thing
pull
on the
them.
screen.
I
on the
know what
it's over
work
me.
is
Look,
this?
look, leggings. I need the ones that are
Well, that's
handmade
what-
by the chat.
I
I want
wearing them.
handmade chat leggings. You're not wearing them. They wouldn't fit on your legs.
How dare you? My legs are perfect and beautimous.
Beautimous.
Yes, they are beautimous.
You couldn't fit my leg warmers on those gams.
I
of
know my
yours.
legs are
I don't
just
believe
long
it.
and skinny. So
I don't believe. Are they? Do you have skinny
yeah,
legs?
I'm very
It's funny.
tall. I'm 6'5".
It's funny. I've never seen this man in person. I have
Yes.
no idea what he looks like. He could be a midget for all I know.
You're like,
That
what
would
are
be
you,
really
a
funny.
cow?
By the way, I got an amazing package today from someone in the chat who sent me all this handmade winter stuff in my color turquoise. Oh my gosh. Hold on. I'll be right back. I have to go get it. You won't believe how good it is.
All right, cool. While Megan's gone, I want to debut my new song. It's called "Never Gonna Give You Any of Your Stuff Now." No, I'm just kidding. That kind of maybe. Bad. No, we I actually, if anybody, the only time I've ever been in public and like really photographed at something in the last few years. I was at Anime Matsuri. So when I was there, I had a mask on and everything, but you can tell like my height and stuff like that. I was on a panel with Law and Hero Hay. It was kind of funny. Man, it was hot there too. Oh my Lord. It was very hot. I had a good time. I love the fact too, like haters really didn't seem happy that we were there. They were very upset. They were very upset.
All right, check this out. So this came from someone who has a little company. I am so in love with this stuff. I can't even tell you. So Pitter and Patter Designs. Sue sent these. This is so cool. Check this out. It's a hat, a beautiful handcrafted hat in turquoise. Boot toppers. So these go on your legs over your boots. These are so cool. A headband. Check this out. It's so perfect for the snowy winter that I'm in right now too. Headband, a cowl, a neck cowl. So this goes around your neck, right? Keeps you warm. And it can go up over your nose and mouth too. So like a, I don't know, like when you go skiing. But this is
my God, they give you a muzzle. That's awesome, Megan.
Shut up. This is really cool. This is really cool. This is a cowl. It's like a full-on like a hat, but with a neck piece. And it's really cool because it covers your entire face. And if you're an introvert, no one can see you in here. Like from the side, you can't see face at all. This is it's awesome. It's so cool. And also I got fingerless gloves, which I already put in the pockets of my coat. So I don't have them up here.
My daughter is obsessed with fingerless gloves.
It's so great. I'm so happy, Sue. Thank you so much. And those of you out there, Pitter and Patter Designs, I don't know if they have a website or something, but they should. Maybe they do. I'm going to look it up. And if they do, I'm going to make them a whole commercial because I love it. The chat wants me to put it on. It's a snood. Okay, all right. I'll put it on, but my hair looks crazy. Hold on. It is so fun. This thing is really cool. Hold on. Oh no, over the earphones. Look at how fun this is. So you like get all in here. Look at the side view. You can't see my face. It's great.
It's cool. You look like a birdhouse. I like it.
I know. I love it. I love it so much. You don't know, like winter in New York is so insane. It really is. It is we're in the wilds out here. It's cold and it snows all the time. I love this. I love it. I'm going to wear it all the time. I love it. Yeah, it looks like a turquoise Jawa. You're right. It looks like a Jawa.
That's funny. Get in my desert and find me some droids, Megan.
Yeah.
Hilarious. Check this out. You want to see crazy?
Priscilla says I look like a garden gnome.
Look at this. This is one package delivery.
Is this all my stuff?
No,
you're hoarding?
No. This was primarily for the kids. Like this is one delivery. Box
Where's
one,
my stuff?
box two,
where are you
box
hoarding all
three.
my stuff?
I told you, in a hole in the yard.
I know it. This is the great thing about being a doxed is that I've now told people just send it to my house.
Yeah,
it's all over online. Just send it to my house. You want to send me shit? Send it to my house. These idiots made sure that my house is completely public. So, you have my mailing address. I guess the good news is they can send presents directly to me, which I love.
Look at that. See, here, Kim gets it. Tugs wearing Megan's leg warmers, doing flash dances. I'm like, oh, what a feeling. That's right.
Dancing on the ceiling.
That's right. See? You want to deprive me of my dancing time?
You don't. You're not the one that wanted the leg warmers. I asked.
How do you know? I could have secretly wanted leg warmers for years now.
This is true.
Maybe.
All right. All right. I'll allow it.
You never know.
I'll allow it.
I know why. That's why, secretly, maybe that's what every man wants. Maybe that's why Bruce is so mangy when it comes to yoga and stuff.
He doesn't look good in yoga pants. Is that what we're saying? Like the yoga pants, it's too much for him.
Shit, I would second like that too. I look like a freaking teeter totter in a freaking pair of yoga pants. I would. Oh my god. I would. It'd just be like, oh my god. All right, let's see some more of these. Tizzy said, by the way, that that Tizzy was up all night getting receipts on that bench of it's not mine, it's the bench, it's for the people, it's by the people, and it's for the people.
Yes.
Mm-hmm.
Definitely.
Think about it. It's actually what it is for real. The point in it, aside from laughing at stupid people, is it is, let's just say it is a quote unquote benchmark for all of the scams that these people have pulled. It is a consistent reminder. I mean, if they say they're going to produce something, if by some miracle something ever did, it would be because we created something and forced them to, you know. But you think about how gross that is. They keep bringing up a family as a shield. You know, they're saying their tragedy, nobody should know about what happens with it. Well, you made it public. You made their tragedy, splashed it everywhere in some gaudy attempt to make money. So how is it not everybody's? You know,
it is everybody's business. They did it publicly. It's everybody's business. They promised a memorial. They raised over $4,000 for it. And it never materialized. I think it should be memorialized. This fraud should be memorialized forever.
And what's worse, again, you know, 2 2x4s. Like, again, they say Hale stole. What proof? Well, trust me, bro, is that. But let's see, is it worse for 2 2x4s to go missing or $4,000 with the memorial bench to go missing? You know? Who stole what now?
That's a very good question. Chat, I want to see you put your support towards this memorial bench. You know, we need bench bucks because the bench is happening. The bench is going to be installed to forever memorialize the bench that never was. This is important. This is a thing that must be carved in stone. It must be there. So that we never forget.
Yeah, we carved out of stone or styrofoam or plastic,
maybe
or
2x4s or plywood. I don't know. It doesn't matter. The point is, it's going to be there for a while, as long as we can possibly.
We must
keep it
laugh. We must laugh at them. You know, I love how.
The bench of shame. Who said that? Helen, the bench of shame. Mm-hmm.
Let's say that they've just been bench slapped.
Get benched.
That's right. I think it's funny though when they tell people again that a memorial was stolen. You notice that a couple of they're talking
who
about
stole the memorial again? Wait a minute. Who stole it? They said it was stolen. There were now 2 memorials in question. Who stole the second?
Oh, they're saying he stole all of it, apparently. You know, one that was tied to some branches, you know, that I mean, you know, again, that one at least looked like it was there to memorialize a place something happened, you know, the specific place. The other thing was a no trespassing sign and a freaking 2x4 sticking in the ground with like a plastic, a flower or something attached. I mean, it was that was not a memorial. That was
it was a 2x4 in the ground.
No, what it was is a giant. It was another Sasquatch with the middle finger sticking up, and I guess since it didn't get its response that they wanted, they disappeared it at night. And then was like, look, you know, what's really amazing to me is they've had cameras on the outside of that fence forever. And I'm sure they have cameras. I'm sure if they have them, that these other people have cameras around too. But they just so happen not to catch Jeremy Hales, like taking this thing.
Yeah, convenient. As AJ's World would say, bench, please.
Exactly. Be like, man,
bench, please.
It amazes me. Like, so many people really bought into this. Really, the only thing that hurt the ecosystem in their narratives wasn't truth, because a lot of these people didn't listen to truth. It was that they firsthand experienced none of this stuff takes place. 13 months of promised bench doesn't show up. Again, that bench just noting that. I mean, we are talking about something that was fundraised November 26th. And thank you, Tizzy, as always, for that date, November 26th. So again, they're saying, well, it's up to nobody but the family, and maybe we'll let people know if it happens. Well, they're telling you right there that it hasn't. It didn't happen. They just made that very clear. Which thank you for that. That's funny. Tomorrow, I'm actually going to talk about how they violated the the protective order yet again. With their stream last night.
Oh
like
my God. Yeah. Well, you haven't sent me the transcript yet, so I can't verify it.
Oh no, it's on you should look at the picture in the freaking stream.
I haven't had time to do it yet, but I'm going to.
Yeah, I went ahead and grabbed
I heard they went off on me, like for real serious.
Oh yeah. Like,
what was that all about?
They were throwing fits. Let's see. Let me see just a second. It was so bizarre because they were. Let me find the timestamp real quick. It was so bizarre though, because when they're throwing their little fits here, it's pretend, some of it. Here, I'm not going to pull it. We should go over this.
Thank you, Rosalind. I just told the chat that they better send more supers so that you stay here longer, because my video is taking forever. You gotta send more supers to chat so that
it's
Tug
funny
will be
because she's like
long enough.
She's like, hey, why don't you tell me about this, Tug? Because she knows I'll just ramble about anything.
Here's the good news though. My video is over an hour long. So you're gonna have content to sit and listen to or fall asleep to or whatever for an hour. It's not a short one. It's a long one. That's why it's taking so long. So
why they were butthurt? Because you made money. They were like, here's an actual thing. They were like, and she's like, only she made her gain of wait a minute. Somebody just rang my doorbell.
I thought I heard that.
Yeah, I did hear that.
Is someone at your door?
I'm gonna look. I've got a ring doorbell.
Awfully.
I'll yell at them at the doorbell if
I heard that. That was weird.
Yeah, I heard it.
Uh-oh.
Let's see.
I don't like late night visitors. No.
Yeah, it's nothing, I don't think.
Is it the squirrel? Is it the mean mugger?
Yeah, that's what it is. It's the squirrel. The squirrel.
Is someone there?
No. It just I think it was the low battery thing. It went off.
Oh, the low. Yeah, that happens. Yeah.
I was looking though. That's what I like. I like the fact that I have 13 cameras around the house here. So
I know. So
you
don't want to hear the little dinging go off.
No, and then, but it anyway, they were complaining. They were like, and she's like, she's playing victim, and she made so much. I heard that she made over $1,000 in super chats that night. Yeah, playing victim. Oh, playing victim like she always does. Poor me, my kids, my car. Oh, I need to fly. Blah blah blah. They were so mad. I mean, and it goes on for pages. Like they really.
Oh my goodness.
Oh, they got twisted, and it's pretty good. I like going through the transcript sometimes. Like I was telling you.
Let's read that part. Didn't you say it was at 1 hour and 8 minutes or something? Yeah. I wrote it down. Can we read it? I want to hear it. You didn't send it to me, so I didn't get to read it.
I know.
I'm dragging this out as long as possible.
I was going to save it for content for Monday, but
come on, we can do it. We can do.
I mean, it's not my chat. I don't care. It's not my live.
We can do it twice. I don't care.
You're like, I'll triple dip.
I'll do it 3 times.
Apparently, Megan is losing her shit. Because I don't know if it's true or not, but she claimed that she got demonetized. See, this is
it was absolutely true. Yeah, the chat was there. They know.
Well, what's funny is they will, like right here is deflection. Like they don't really upset. Look at this. Jeremy's a little upset about Megan getting basically put in her place too. Did you know you got put in your place?
I didn't know
Yeah,
that.
apparently George put you in your place. Yeah.
Who?
Apparently
George?
Yeah, apparently I didn't realize that.
Wait, what?
Yeah, you have to read all
Wait,
this.
what the what now? George put me in my
This is so this is a new narrative. So apparently, you know that
George and I are fighting.
Okay, so I'll note this and we'll go over it tomorrow and more. So they pulled up a video of a car again saying it's George. But guess what? It's not George. Right?
It wasn't George.
It's just it's not that. But we'll go over that in depth tomorrow. But in that, what they're saying is they called out George for going by not filming, which was not George, by the way, and the first time that they did this, so they got it wrong both times. But they said this time the person slows down. It's pitch black outside, by the way, in the video, so they're going slow on a road in the middle of nowhere, and they're like, you can tell they're recording. So they're saying that George decided to start driving on the wrong side of the road and filming because Jeremy got mad at her for being called out for it. So that's what all this is about. They pointed it out and bam, right there. And then somehow, in some way, you work into that. I'm not sure.
What?
Yeah, I don't know, man. You have to, again, there's a lot of, there is,
George. Okay, look, I just want to, for the record, George and I are totally cool.
Yeah, George. I mean, this is.
I love George. I think George loves me. We're good. Like, what would this have to do with? I don't.
It has not. Well, you know, it's the same thing. It's. I mean, they again took a car that's not George, made it George, and then said that Jeremy had gotten mad at her because he was the only one driving down the road filming and, you know, doing all this stuff. So he must have set her straight because she was doing it. When again, it wasn't her again. So it is the most insane stuff.
Everybody who works there films when they go by that way, just in case.
Well, they're taking also when they're talking about cars going down the road at night. This is video they pick up in the middle of the night. You can tell, you know, car is slowing down. First of all, remember,
did you take screenshots of?
No, I took the whole video. I got to read the whole damn video part, you know, so it's all there. But then they start going into you about you supposedly losing your shit, you know, because you had gotten either 3 strikes or reports or 3 somethings. I don't know. Now they do know that that's.
I got 3. Let me explain. I got 3 age restrictions this month, which is very unusual. I think in my entire 15 years on YouTube, it's only happened 2 times until now. And it's happened 3 times in a month with nothing in the videos that was what they said.
She got 3 strikes and her channel should be down. I don't
know.
No, but it's
not
3
strikes.
Somethings. She's demonetized. And she's like, which only made her gain 1,000 rants or something on Rumble. So she's playing it now again. They know this isn't true because they will change it up. Look. Because again, right in the same sentence, but you only got 1,000 rants, but so you're playing victim, and she made much better. I heard she made over $1,000 in super chats that night. So how that night, if you are demonetized and only making money on Rumble through Rumble rants, how are you making super chats, which is indicative to YouTube?
Right.
So they know the truth about this. They just try to play this. I mean, again, it's just slush mouth game of bullshit. But
I had to start a brand new stream. I couldn't monetize that stream.
But that's not what they're saying. They're saying your whole channel. I mean, you've been struck 3 times.
That's not right.
You get demonetized.
No, that's
you can
wrong.
only make money on
It's
Rumble.
not a strike. When you get age restricted, it's not a strike.
It's just an age restriction, but it ruins your
stream. You can't get super chats. They won't monetize it, and then it won't monetize in the future either. So when the stream is done, you don't get credit for the ads that they run on it. Right?
I like this idea, by the way.
Oh my God, Skipper Trucking, you're out.
1 for each. I love it. That's a great idea. My
God, I hate you right now.
And I'll send you a picture for your birthday.
Just send me the stuff people sent for me. It's mine.
It
We're
is.
gonna
It's
end
still
up in-
yours. It's still
We're
yours.
gonna end up in
It's
court
like the
over this.
memorial.
I'm
It's in
gonna sue
process.
you.
I had to
I'm
ship
gonna
it from
sue you.
China.
I'm going to sue you.
I had to ship it from China. It's right there with the memorial bench.
You're in Tennessee, and that is not in China.
I'm telling you, I had to ship
No,
it
you're in
with,
Tennessee.
the Anti-Hales memorial bench.
You know what, chat? I want you to know that this man told you could send things to his P.O. box and he would send them to me.
I didn't say when.
He has never sent me one thing.
I never said when.
Not one.
Ever.
I can't believe I believed him. He hasn't sent me one thing. So all of you out there who are like, man,
Semantics.
I sent her things. I sent her things and she never said thank you. She never acknowledged it. I never got it.
Thank you. I appreciate you sending them to me. That coffee cup, that's cool. Let me see what else is there. I think there's a hat.
Dark
cool.
Mage says mom and dad are fighting again. The chat gets so upset when we start fighting. It's so funny. They're like,
oh my God. I hope nobody takes it.
My anxiety is over the roof.
I hope, for real. I hope nobody in the chat ever takes any of this goofing off.
No, but it is true. He hasn't sent me anything that belongs to me.
Real.
That's
like,
true.
For real, no,
He's holding it.
Every night I pull out the leggings and I karate chop them a few times and like, Megan, this is what you get.
Yeah. You know, I may have to drive there to get them.
It's kind of like a voodoo doll, you know.
I may have to just drive to Tennessee and show up at his door and be like, knock, knock, knock. Can I have my shit, please? That would be really funny.
Like the septic tanks in the back.
You're gonna be like, get away from my door. My doorbell reloads. Nobody invited you here. Oh, you know what I'll do? I'll send Dave Neal to his house. Dave will send them to me. Dave can pick them up and Dave will send them.
That would be hilarious.
It would be if Dave showed up.
Make him come on horseback though.
On one of Laura's horses.
Yeah, that's exactly. He's got to come on horseback because if he doesn't, then it just ruins everything. But here, yeah. So you're playing victim. You made your $1,000. Yeah, playing victim. Lots. Yeah. Playing victim.
How am I not a victim from false accusations and false hits on my channel? How am I not the victim of that?
I just love like his poor me, my kid, my car. This I need a blood. Blah blah blah. Oh, it's so butthurt. Meanwhile, she's the one with like 50,000 subs. What? How many thousand views? Well, first of all, you realize when they're talking about 1,000 views, are you kidding me? You're talking about actual videos, you know, with niche topics, because niche topics, you can cover mainstream items if you wanted to. If you chase the mainstream, eventually one item will hit and hit hard, you know. And I mean, a lot of people do that, but you cover cases that matter. It's funny too. If you don't make views, then what are they saying about people like Miltoast? You know?
That's really funny.
If you're a failure, then what's Ray?
True. Also, I do have news on my car, by the way. My car has been sitting at the mechanic because Dodge never sent the check. It is now December 12th, and the check finally showed up today.
Wow, it took that long?
Uh-huh.
You'd think they shipped it to me first or something.
You would think to Doug first.
That's pretty funny.
My car, now we finally have the check, so now we can tell the mechanic to go ahead and like fix the car. But I mean, I've been without a car now for, I don't know, when did I return the Ford F-150? That was a while ago. I have been sharing. Luckily, it actually worked out that everyone in my house got a virus because my husband worked from home because he's been so sick. So I've had his car to take the kid to school and whatever stuff I need to do. But it has not been fun sharing one car. On the days my husband has to go into the office, I'm no wheels. So if my kid gets sick at school, I can't go get him. I mean, it's been rough, and it's been weeks, and it's going to still be more weeks because now the transmission has to be replaced, and that's going to be that's a long repair. It's not quick. It's not, in, out. So it sucks. So I don't know why she's criticizing me for having car problems. It's a bad problem. I have a blown transmission. It's not drivable.
Oh, now they're trying to tell their chat that you cover at first sexually based things, and then
fuck them.
Yeah, and that you should essentially they're.
Didn't one of them say that there were boobs on my channel?
Yes, they did.
Fuck them. Like no nipples have ever been shown on my channel. No nipples. If you're talking about cleavage, fuck you. Second of all, that video of lips had a lot of cleavage, but there were no nipples. And if there had been, I would never have shown that. I would never. I'm not an idiot.
They also went after Leslie's father. They said that he is really twisted. It was like,
let me clear that up. Leslie's father did not send me that video. I'm not going to reveal my sources, but it was not Leslie's dad. And I'm not the only person who it was sent to. There is a tip line that we ecosystemtips@gmail.com. That video came into that email. And it was not from her dad.
And then let's just say we found it through some archiving stuff and everything else. We could back it up. It's provable.
Yeah, we can back it up.
And she already proved it anyway because she admitted it was real. Yeah. But remember how at first they said that you were a liar and that none of that stuff existed and you'd made it up. There were no things like that out there and you were going to be sued for it. So then when you proved that it was there, then you're a monster and they go after the dad for something that, again, did not do.
He didn't do it. No.
Then on top of that, here was a really funny one too. I liked this little quote here. They were talking about Leslie and you, and they were like, well, what I don't get, I mean, the big thing is making the whole point of talking like, since when did Leslie become a hot topic? You know what I'm saying? I mean, there isn't a case with Leslie. Well, I mean, there is a lawsuit or whatever, but
she fucking sued me, and I am now suing her. There is a case. There's a big case. There's a very serious case against Leslie Ferderigos and her husband.
Well, there's a whole nother rant about you on other pages too with Leslie and Megan.
Oh, fantastic.
Yeah, they spent probably, I'm going to say 7 good pages talking about you. And
I love it.
Yeah. I mean, it's funny. It's funny because it's stuff to take shots at. They also, yet again, took Miyagi's location where she's from, and they dumped it out there in public. So they did dox where she's from. And again, why did they dox that? This is somebody that they learned this information because they gave money. That's how they got a hold of that information. So they're doxing donor information. I mean, that's wild to me.
How do they do that?
What do you mean?
Like, why do they do that? Why do they dox information of people? This is crazy to me.
It's to keep these people in line, man. It's crazy because, like again, if you're allowed to have a difference of opinion. If you're chatting or whatever, some people make videos. I don't like, again, there's a line. If you're going to dox or anything like that, yeah, we have a problem, right? But God, we ignore most freaking channels. I mean, if even in this thing, if it's not one of these major channels out there, who cares? I see a bunch of them pop up. I mean, hell, even certain people that they're auxiliary. The only time we get like a Thomas Collins, anytime he stalks the freaking properties over there all the time, man. Don't cover that. But John Cook, when he's going to pop up in them, oh yeah, I'm curious. I look in to see if John Cook. I actually have gotten to the point where I zoom through his stuff just to see where John Cook is going to pop up in the video today. But, It's so bizarre.
He's like one of those games you hit the gophers on the head. They pop up.
Yeah.
He pops up, bam, 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 bam.
Get back under your shitty freaking fence. But I love how like he's like, oh look, we just happened to run into John. It's like,
oh my God.
I don't think that's how that happened, you know. I'm gonna hit some super chats. How long do you got before that, ma'am?
I don't know. YouTube takes its own time, you know.
I will read it.
Look, chat, delay chat, more super chats, more bench bucks. You can do this. You can keep him
shown, baby.
You can keep him on the air as long as it takes for my video to, process, because it's going to take a bit. So just keep sending super chats, and then he can't go anywhere. And you want this. You want another hour of entertainment, don't you? I mean,
I can't remember what we were talking about one time, but somebody broke me at one time and was like, "Oh man, you and Megan fighting? It's I was like, we're not fighting for real.
We've never fought ever.
You're like, oh my gosh, Well, but I think people see that, and a lot of time, like especially if you went over the ecosystem and you see people like that, they're not friends. So if they ever have any kind of discussion, that doesn't look friendly, it's probably because it's not friendly, It's
Look,
not
chat,
good.
Tug's one of my best friends. Like, he's probably my best friend. Like, I talk to him more than anyone else. Don't worry. We're fine.
We talk about all kind of stuff. Yeah, you can tell. I mean,
I talk to Tug every day, not just on the air, but like off the air, where we talk all the time. I'm very grateful for Tug. Very grateful.
Yeah, same here. We have a good time.
I need, it's good to have somebody who answers your texts right away. And it's awful. I was talking to my daughter, my oldest. When you move away from a place where your kids have roots, she was 10 when we moved away. She has had such a difficult time finding friends where we are. And it hurts her really badly. She just has no good friends. And it is rough. And I'm grateful. I'm so grateful to have she even said it to me today. Well, I texted so-and-so. I do sometimes, and they don't get back to me. That sucks.
My oldest daughter, she had a friend that they were texting. I don't even know what happened with this. They would communicate and text. They were fun, good to go. Well, she was going through, I guess, a rebellious time, the other kid. And she probably said something to her parent that she wasn't supposed to. And you know how that goes. They blame it on the other kid you're talking to, usually in that. And they just ghosted my oldest. So, she had this one friend. She thought, oh, that's my best friend. And then they just disappeared. And man, that was crushing. I was so mad. It was like, it took everything in me not to drive over to someone's house and yell at some parents.
In this, it's so sad. My oldest is 19 years old, and I thought she'd find her people at college, and so far that hasn't happened. And the longer that goes on, the more it solidifies that it's never going to happen, and it's hard. Sometimes I wish we had never moved, because they had good friends where we were. They had good little friends, and it's rough. So I'm going to hang out with her afterwards. We're going to watch a movie and do some crocheting together, because I am her friend. I think she's great.
That's what I tell my oldest. I'm like, man, I like hanging out with you. And I do. I enjoy hanging out with my kids. They're fun. They're good kids. I don't know. I like them. So.
I love my kids, and I think they're fantastic. I don't know why, but she hasn't connected with anyone here in a way that is meaningful, and that sucks. It's
a lot of people
sucks.
So detached these days. You see it a lot. Like a lot of people there. Even when they're friends, they're like, "Yo, why don't you just text or this or that?" Man, it's so disconnected. There's no people like getting together, doing things, and it's just, I don't know, it's kind of lonely in its own way.
It is. A lot of people are lonely. That's what I told her tonight. Was, you're not the only person who's lonely. Somebody out there wants a friend. Eventually, you're going to find her. you know?
Yep.
And
Yeah.
but it's rough. It's rough. And I'm very grateful for my friends, including Tug. Believe me, I'm grateful for it. And we're never at odds. That's never true.
We can, yeah, but the thing is, like, we are allowed to have our own opinions on stuff too. You know, we can argue over stuff. Like, one of the things that it's the same thing. Like, I have a few friends online, like Yellow Flash, for example. Man, we argue sometimes,
Mhm.
and people would be like, "Oh my god, you know, this is going to be like a blood sport or something." It's like, no, man, we're just arguing about nerd shit. Yeah,
Arguing is fun sometimes, you
yeah.
know? It would be super boring if you were like Stacy all the time and being like, "I agree. Yes, that's right, Lisa. You're right about everything. Oh
Oh,
my god.
Megan, I
I
love your
totally
giant heart valves.
everything you say is great. Everything's shut up, Jacob. Shut up, Nine Chins. Yes,
Yeah.
Lisa, everything you say is great. You're our leader." Like, that's boring,
Oh
you
my
know?
God. So one of their big people that used to be a donor, somebody mentioned them and they were like, yeah, they're doing okay. They're doing, and then they cut it off. And I was like, I wonder
Hmm.
if, because they used to, you know, there was another pretty big donor that they had at one time. They had a couple of them. And apparently that one is strayed too. You know, so they've been
Mhm.
claiming they have another big one matching. Now again, maybe they're real. Maybe I don't know. You know, we never see any proof of anything, so I'm not going to take their word on anything. But I
Mhm.
can't wait if they are real. I can't wait for that moment when they ask a question about how their money's being utilized and they get to sit on the curb. You know, and they expect other people to be like, "Oh my God," and be outraged for them. You know.
Yeah.
What suckers, man. I can't believe
Suckers.
people are giving them large amounts of money again. If they are indeed.
Well, if they are.
Yeah, I said if they are indeed for sure.
If they are. I would find
Mhm.
it hard to believe, you know?
Yeah, I mean, at the same time, you have some people that are, I mean, fanatically cultish. I mean, they were singing cult songs for fuck's sake.
I know. I
You
know.
know, that's one of the weirdest
The
things I've
cult
ever
songs
seen.
were so funny, especially because she wasn't even interested in them. She was, like,
Yeah.
talking over it, not paying attention.
Yelling at the chat like somebody, you know what I'm it was so bad the person started the songs over, you know, to be like, "Oh, these are
You
really
gotta
important.
listen, they're really good.
I put my heart and soul into this, Lisa. It's just for you, Lisa. Just for you." And she's
Just
like,
for you.
well, you know, that damn person in the chat, screw you. You know, and you hear them like, Lisa, I would scrub your toenails because I love you. Yeah, I would massage your giant heart valves. And she's like, oh my God, I can't believe this person. And she's eating chicken skins and coffee. It's
Oh my god.
gross.
I would massage your giant what now? I
Extra large and extra large.
I would massage your giant what now? What the fuck? More like. I can't wait. Like later on, one doctor is going to be like, you know what,
Tug
nurse?
is our protector.
Oh my God, that's what I need. Megan Fox, our protector. Oh my God. Here. Oh man, I wonder if AI could write me a song about Megan Fox, our protector.
Oh no.
Yeah,
Oh,
let's see.
Slug. Slug is writing a new book. Oh my God. He writes books now. Did you know that?
Really? No.
So since he got kicked off of YouTube for God knows why, I don't know. I don't ask questions. He got kicked off of YouTube. He's been writing books. He's writing superhero books. And he has based a character on me. Oh yes. Yes, he has. And let me read to you his character based on me. This is so funny. Each hairstyle she has unlocks a new ability. And I love this idea. I really do. He's been writing actual books. It's incredible. Wait, where is it? He tagged me in it. Where the heck did it go? Hold on, I'm finding it. Here it is. Breaking news. The superhero Neurotica, by the way, I will kill him later for that name. Neurotica. I'm not neurotic. Fuck you, Slug. Has been arrested for the mass intoxication event at the Gladiator Charity Gala. 12 heroes have been hospitalized for extreme intoxication, while everyone else is going to be having a bad hangover tomorrow. Neurotica, known publicly as Megan Vire, has been sporting a new hairstyle based on the Roaring 20s flapper aesthetics. But many enhanced researchers have just discovered that her abilities have caused forced intoxication due to the flapper style she supported last night. Law enforcement is on the record stating that the charges could even be for attempted murder due to how intoxicated some of the heroes were when first responders arrived.
Like, if you can't hang with me, then I don't know what your problem is.
I responded on Twitter with the GIF, we're all streaking. We're all. Oh my God. He's literally writing superhero novels. He's already gotten, I think, 2 of them done. And I appear in the 3rd one, apparently. So you guys need to go check it out, because you know what? Slug is a really good example of somebody who went down a dangerous path and turned around and realized he was doing something wrong and said, I don't want this for myself anymore. And I don't know if it was when we roasted his scrambled pancakes or whatever, but he saw the light and he decided he wanted something else for himself. And I am so proud of him.
You know, what amazed me was when he just questioned some of the stupid about false flagging, and these idiots, they turned on him so quickly, and it was, you saw it, and that it kind of blew my mind. I don't expect them to have loyalty or anything, but my God, the speed at which they turn on people just blows my mind.
Mm-hmm.
But yeah, Skug, it's good. Like, he also didn't play the victim out when it came to all of that stuff. He was like, yeah, I did.
He did exactly what he did exactly what you're supposed to do when you screw up. I'm sorry. I'll never do it again. What can I do to make it up? Period. End of story.
Well, that also, it's funny enough, that's the difference. So they've been talking again about the Topher situation, right? And they're like, oh, well, there was retraction. There was this. Sure there wasn't. I watched how that stuff went, and they doubled and tripled down on the idea that all of this stuff, you saw how they covered it. They were like, well, even though he's filming over this and doing that, essentially, you just can't say it with that certain word. I was like, that's not really retracting what you said.
Right.
Oh my God. But he knew that. That just was it worth it? And again, they want to argue that calling somebody that it's 100% free speech. I can have an opinion. I was like, labeling somebody a PDF file is not just, hey, that's my opinion. that's life ruinous behavior. And they know.
Absolutely. And I think Slug learned that very quickly.
Yeah. Well, I think he learned who he was dealing with too.
He did. And he really did an entire turnaround of his life. And I'm really proud of him. I really am. He has a Substack up that he has been posting his chapters before he writes them or before he publishes them. So I'll throw it in the chat for you guys. If you want to go check out Slug's fictional writing, he's writing superhero books, and it's a lot of fun. Really, they really are. He's being so creative, and I'm just proud of him for doing it. So go and check out his Substack. I'm going to put it in the chat for you. There you go. And check it out, because he's doing good things with his life. So good for him. And he has a new job, and he's just doing good. So
that's good. That's good.
Yeah.
I'm glad that some people have been able to successfully detach themselves from this freak show that we've seen roll in.
Yeah, and I mean, look, it's great to see somebody go and do something in the real world. He literally published books. That's great. Like it's hard to write. Lots of people say, I'm going to write a book. And it doesn't happen because it's hard to write a book. It's very hard. I know how hard it is. And he did it. So go support him because he did a good job. I'm gonna buy book 3. I'm probably gonna read it on my channel. It'll be hilarious because apparently I'm in it. It's funny.
My guy that publishes, we know a guy that, well, he's done a lot with the other stuff that we put out. I'm going to talk to him when he gets back from his holiday stuff about the chicken skins.
Chicken skins? Oh, good.
I want to see, because side saddling, like typically, something like this, you could side saddle it, like a comic book or something and goof off. But it's so big right now, I don't think it would hold the weight, So it might have to actually be put into some kind of hard backing form or, a fatter paperback. I'll see. That's what they specialize in. But yeah, it's it's kind of grown to an obscene level. It's got like 16 freaking thousand words. And I'm like, man, this is a novella for making fun of idiots.
People are going to like it. It's going to be good.
It's been fun. I just, every time I start to move on, like now I'm like, man, I need a new chapter about filming over fences, and about how you give cameras to other people, how you let them film the wrong cars and break your protective orders.
Of course.
I have my favorites, by the way, noted. And thank you for the year there. My family appreciates all the prayers for my son. His surgery went well. I'm glad his surgery went well. He's in pain. Hopefully they're doing something for that. We found out his, so it's a break. It's not break. It's just a spread. Hey, that's good then. That's good. But again, prayers for you and your family for sure. And everybody, because I have my favorites there. And again, we love you. So we appreciate you too. The floofies. Thanks for the 7 months there. Pleased to be a floofy tugs Doug. That's right. I mean, I'm pleased that you are here too. It's funny. That is one of the littlest ones. She's like, the floofy cat is here. It's so funny.
All right, this is super weird, but YouTube says my premiere has already started, but I didn't start it till 11. So I guess I can't change it. It says it did, but I don't know if that's true. But it's out there, so you can redirect probably, I guess. See if you can.
Let me check and see if it'll lock on. If it's already started, yeah.
But it shouldn't have already started because I set it at 11, but I didn't think it was done.
Yeah, well, can you reset the time if it's
I tried and it said it already started.
Oh, shit.
But it didn't because it's 10:58.
Because it might see it as as long as it's on, I can maybe still catch it.
Maybe you can. I don't know. If you can't, it's fine. I'll put the link in the chat when the
cozy winter reading.
Yeah, that's it.
Yeah, I can still redirect to it. So
all right, awesome. All right, so don't worry. Don't go now. Go later. It's fine. You'll still get to it. Yeah. All right.
You go check it out. It doesn't matter one way or the other. Check it out then if you want to.
Whatever.
Whatever. Pull it up while I'm talking too. It's gonna be an hour. That's about how long it takes me to read Super Chat. No, I'm just Christian Mom. Thanks for the 5 months. Travis showed the new memorial poll today. Oh my God, I gotta see.
There's a memorial poll?
I gotta check that out. I gotta see what he's saying. Somebody send me a picture of that. I want to see what's up with that. Tracy, thank you for the 5 giftos there. Thank you, Tracy. That is awesome of you and much appreciated. Thank you as always. None ya beeswags like that. Thank you for the 6 months. Lurker check in. Well, thank you. Getting the lurkers on task. What's be rad. Thank you for 3 months, my friend. Been there longer than that, by the way, for sure. Appreciate you there. Thank you. Emmy, thanks for the $50 bench fund and to make sure that we have the ashes of the previous bench. Throw away like Tina did with the real ashes when she lied to the man. Oh, that's awful. It's sad. I hope, you know what, one of the saddest stories I think has come from all of this stuff, honestly, is the John Cook ex-wife ashes in the shed. Because you know,
well, I don't want to say it out loud, but I bet there are people who have things to say about that.
Yeah, actually, I know something else about that, but I can't say.
Oh, do you?
Yeah, I can't say that.
You didn't tell me.
Yeah, I just found out. I'll tell you later. Remind me.
Okay, I will.
Thanks for the 2 there for the bench. And by the way, people, again, you will want to be there Tuesday. You will. Next week, I told them next week will be amazing, crazy week. Like not just that one day.
Yeah, it's going to be insane.
Nuts. Anna, thanks for the 5 there. Benchmarks. Thank you. That's awesome. Appreciate it. Turtle Hurdles. Thanks for the 10. Payment for the bench warrants. Mr. Landfill. I like that. It's funny. Thanks for the 5. Bench bucks. Get those bench bucks on, baby. Joe, thanks for the 20 there. For the bench, the judge is going to throw at the ecosystem legally. We should give him a little one so he can throw it at him. Wow. Or a big one if he's really strong. I don't want him to strain himself. Jen, thank you for 5. Did Bruce or Lisa interfere by writing to Owens accusing Jeremy of perjury like they have done with every other judge and court case? Well, I read to them when this came up. I read the note that Lisa, of the conversation. So they definitely did call in and try to interfere, and I'm sure other ones did too. They talked about it. So we know they all were calling in to Levy County and trying to get Jeremy Hales arrested. Absolutely. And they were humoring them. That's the grossest part. Wheezy Wheels, thank you for that gifted membership. Thank you, Wheezy. Much appreciated there. Bonnet, thanks for the 5. It's hysterical and the fleas are losing their minds, which makes it more funny. That's true. We need to do a pool to fix the middle finger. We don't fundraise. Oh yeah, the middle finger thing. That's actually pretty funny. Yeah, I could fix that really easy. Give me a chainsaw, I'll fix it. It won't be a middle finger anymore. I'll throw it back over. I'll take it off and throw it back to somebody. Mary, thank you for the membership. Thank you. Welcome. Thank you for that membership and welcome to Tugs Thugs. Thank you, Mary. That is awesome of you and much appreciated. Kathy, thanks for the 2. Lurker tax. Playing those lurker taxes, baby. Thank you. Appreciate that. And thanks for the 5 there. Fantasy Island Fleece of Florida edition. The bench instead of the plane. It's the plane, boss. It's the bench, boss. The bench. I like it. Irish Lace, thanks for the 14 months. Love the anti-bench idea. I know I love it there. I absolutely love it. And people have talked about like a bunch of add-ons and stuff. You got to remember, this is on someone else's land, first of all. So I don't, and it has a purpose. Again, the purpose in all of that is a reminder to point out what these people have done. For real. You can say it's a laugh, sure, but you literally set a place aside to ponder what they have done, to think about the bench that never was, and then, the barn that never was. Love it. Let's see. Whoops, they rolled down on me for some reason. There we go. Thank you, Irish Lace. Tofa, what's up? Thanks for the 2. Tuck, I've never been on that shit show. It's true. Wrong Tover, my friend. That's right. Take that name back. That's what I tell anybody. Like the Johns out there, the Lacey's or whatever. Take your names back. Jen, thanks for the 2. Brilliant work from Randy. Yes, that was a great filing. It was. I loved it. Tizzy, thanks for the 5. Do super chats count toward the bench tonight? I need to know for my folder receipt. Do I play like anti-rules, if they don't specifically state that, and no, I'm just kidding. Count them if you want. It doesn't matter. You know, count whatever you want to work. You know, like I said, we'll have a bench manifest, so it'll be glorious. Here's your down under. Thanks for the 2 months there. 2 months. Where's the time go? Yeah, much longer. Yes, you've been here much longer for sure. Thanks so much for good work. Love you, Tug. Gang, gang from Aussie land. Gang, gang indeed. Thank you, too. And you have been here for longer for sure. SF, thanks for 5. I hate when mommy and daddy fight. I know. It's sad. I'm sorry, kids. Re-rise right here. Look, Megan, possession is 9/10 of the law. Just saying. That's true. That's true.
Oh my God. He snowed me. Damn it.
Well, you know, whether we're talking about leg
it's
warmers,
your stuff now. I said they can send it to you. You could keep it if you wanted to. Under the law, it's yours. God damn it.
I've always wanted a coffee cup with Megan Fox's face on it.
I want my leg warmers.
Well, you know, it is might chilly here. Maybe I'll go put them on real quick.
If you're
like, why do they smell like popcorn butter? What's going on? What kind of freaky shit have you been doing? I don't know. I put on some popcorn butter and I rolled up in my electric blanket and saw if it would pop
rolled
me.
up in your electric blanket.
Pop, pop.
You and your
and I make the noise.
blanket.
Pop, 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 pop. You're like, what the fuck is that? Aubrey, thanks for the tip. My not memorial contribution. Thank you. And love and hugs to all. Well, love and hugs returned. And thank you. Kim, thanks for the 17 months. Tug is wearing Megan's leg warmers. That's right. This is the flash dance too. Oh, what a feeling. Love it. It's funny how you can't stop. Like
I know, I can't stop.
Melissa, thanks for the two. For the son of a bench. It is kind of, it is like kind of its offspring. So it is really a son of a bench, isn't it? Huh. That's crazy.
Son of a bench.
The bench that never was. Oh, love it. I'm having so much fun there. Sherry, look at that. For some reason, I'm picturing Gumby when Tug says he's wearing leggings. Yep, that's what I look like with them on. I probably would look like Gumby, actually. That's hilarious. McDeb, thanks for the 5. I doubt very much if Jeremy would do anything in cover of darkness. He's a stand in the sunshine, kind of flip you off guy. Yeah, that's about right, too. I doubt that they have anything that they could prove with, because again, if they had a video that they could show that definitively showed anything, they would have put that out there a million times by now. Look at what they try to go with.
Oh,
they
yeah,
show
they
the
would
man
have.
driving down the road.
Absolutely, they would have. No doubt about it.
Oh, love it. There's Rosalind Duke dropped the Here Longer Fund, and on top of that, the Butt Hurt Fund. Sometimes you need salve.
Nice.
I love
Thank
it.
you, Rosalind. Thank you, bestie.
Michelle, thanks for the 10 there. Use for whatever. Don't care. Heck yeah. That's what
Heck yeah.
I love it. Heck yeah. That popcorn buddy, here we come. Cat, it's so dumb. Thanks for the 5. Thank you, by the way. Thanks for the 5. Willing to provide tutorial for making bench cushions with duck fabric. We'll see. I have no idea what our wonderful bench will look like yet or anything. Again, like Jeremy has the discretion of looking and deciding.
It's going to be great.
Yeah,
he gets to pick it.
Though it's on his again. I want to reiterate, this is on his property, so it's not like when we created Lego versions of stuff.
Right? No, he gets to pick what goes on his
and we
property.
can't turn it into a giant shit show because it has to be
right.
So that's one thing with tempering the resolve of it. SF, thanks for the 2. Please give to Megan for more butt hurt funds.
He won't give shit to me that you give him to give to me. Have you not learned this by now?
No, that's definitely not. Right now, send super chats to Megan Fox right now. I will totally not give them to her.
That's okay, because I have a live stream going. I have a live premiere going right now. You can send super chats over there.
Yeah,
So.
or you could send them right here, and then I'll read them and say, "Hey, Megan, don't you wish this were on your premiere?"
Yeah, I'm a little annoyed by that. I'm a little annoyed. 9 minutes in, I can't stop it. It's what it is.
I know, it
Is what
does
it
suck.
is.
It came up for real.
I
I'm
know.
moving fast for me. Okay.
Yeah, you are. You're doing good.
This is for you, Megan. Delay tactics. Hey, Tug. It's for her in spirit. That's what it is.
Thank you.
Thanks for the 5. Delay. There you go. Thank you.
No more delays. No more.
Feather catcher. Thanks for the 2 there. Lurker. Well, hey, love to the lurkers. Thank you. Skipper. I loved this idea. I will think about that. You know, I love it there. Skipper. Also, thanks for the 7 months. These dopes strike more than Teamsters. That's true. That's funny. I love it. Skipper also said, Megan, I'm in Portland, Tennessee tonight.
Yes.
Would you like me to pick them up?
Yes.
For you?
Can you pick them up and drive them to New York? Let me know. I'm all for it.
There is a
scavenger. He's never going to send them.
Teddy, thanks for the not, especially not now. This has just become fun all of a sudden. Thanks for the 15 bench bucks or whatever is left over goes to whatever is needed, cemented to the ground so the grifters don't try to move it to their property. Yeah, actually, whatever's left over, very clear, it goes in the pocket of the person that is raising it. And again, you know, that is noted with the person that, like I said, we're putting it on Hale's property with permission. That was 100% noted before I ever brought this up. You know, I want to be very clear about that. I wasn't like, hey, by the way, I'm going to put this on your property. You good with that? You know, all right, let's see. Wait, hey, I got it. There's a 20 also with PayPal for the girls' Christmas. Thank you. I'm going to say MH. You know who I'm talking about there. Thank you very much. I appreciate that. I would shout out every name. It's you know, it shows real names, so I don't always know if I should or not. So I'll go with initials. Debbie, thank you for the 5 gifted memberships. Thank you, Debbie. That is awesome of you very much. Appreciate that. Michelle, thank you. Dropped a gifto there as well. Man, I love giftos. Thank you, guys. Travis, thanks for the 5. Me and my best friend do transmission rebuilds in the day, so definitely make sure they ain't ripping you off price-wise due to it being an insurance claim, Megan. Yep, that's for sure. Anytime there's rebuilds or a transmission, heck yeah. Luigi's mom, thanks for the 2. For the bench, Shizzy already has an acorn. I heard about that. Cap, thanks for the 2. In honor of the trashed trash bandits. It's funny. Thank you. Just thanks for the 2. Stacy Nat got a gifted membership. Stacy and AT got a gifted membership for today. Huh? I hope somebody sent me a screenshot of that. That's hilarious. Kim Sin, thanks for the 10. Benchmarks. She sent her little cultists over here to get screenshots. They're over here. I love it. K-Matt, thanks for the 5. Bench Wars. Funds for shipping fees. Thank you. Bench Wars.
Bench Wars.
Thanks for the 5. Okay, the BS is getting deep now. Yes, indeed. When you read through those transcripts, they're nuts. Rosalind, thanks for the 10. On and on and on. Never going to give you up. Never going to let you down. Never going to run around and hurt you. Never gonna make you cry. Never gonna say. It's actually through here. Never gonna give you.
We're getting rickrolled. I love it. I love it. Rickroll us. Rickroll me harder, Daddy.
It's hilarious. It's a thing like that. Mug is a national treasure. We must protect them at all costs. That's right. That's right.
True. The mug anniversary is coming up. I'm just letting you know. It's coming up.
Just Jay, thanks for the 5. I like a good apology that starts with, he's an a-hole.
You know what? I got to give Slug credit. He totally did. He was like, I was totally wrong. There's no excuse for me. And I'm not doing this ever again. That's the way that you need to do it. Listen, he's a good guy. Like, I've met him in person. I literally drove an hour and a half to see him in Pennsylvania when he was coming through to do his spam tour He was doing a spam, I don't know if it was like the spam museum or something tour. And he's a good dude. So go support him, buy his books. He's writing superhero books, and I support that 100%.
That is definitely much better than, it's a heck of a change from
It's
from
a heck of a
there.
change, but it's a good change. And
Yeah.
I support positive changes for people. Yeah, 100%.
Well, any of these folks too, when they were in the ecos, they'd been tied in. I had some real disagreement with looking at, anything they did. And I have been pleasantly surprised by him. So I will say.
Totally.
Rosalind. Thank you. Rick Rowland too. And Just Jay is like, this is super chats for Megan Fox to give to me.
Damn it.
Yay.
Jay, you know better.
Yay. Good job. I love it. Oh my God. There is Stacy and AT getting her. I'll save that for tomorrow. That's beautiful. I'm gonna put it in my I'm gonna put it in everything in the front. All right. I'm gonna end here. We're gonna redirect. All right. So while your thing's still up. Appreciate you folks. See you later.